With your permission, Lordship, I beg to mention for listing of a bail application.
The listing, you will have to go to the
Court number 9.
senior bench. Or if less than 7 years, this.
Less
I
than
do not-
7 years, Lordship. The punishment is less than 7 years. That's why I am mentioning. For tomorrow, my Lord. Clear.
Wait, Lordship. I beg to mention, criminal revision number 166 of 2018. It was listed on 9 last week. It got adjourned. So I had to refix the hearing fixed matter on Monday.
Now what to do?
Stay matter is involved. But
No, I'm not getting. What is your prayer?
my prayer is that it was listed on 9 last.
Yes, yes.
It got it adjourned. But till now it has not been listed. So I wanted to be listed on 21st Monday.
You
And
make a
it's-
mention before the senior bench.
So it was before your lordship.
Maybe was it a part heard?
No, not perfect.
Revision.
The Botakur for I think for mentioning you should go to the senior bench except those bail matter where punishment is less than 7 years.
Mine is your Lordship less
If
than
bail
bail.
and less than 7 years, you can
No.
make a mention. Others for listing it should be the senior bench.
But in my case, the senior father order that is not by his court.
That will automatically come to this bench.
So if there is some urgency, lordship,
Okay, then you that I can give you permission.
then the urgency is like that.
See, until and unless a matter is part heard, I cannot say list this before this
Yes,
court.
Yes.
We do not know that may be listed in the other bench also because both the benches are taking all revisions matter anything. But there is a caveat that bail so far relating to less 7 and less than 7 before this bench. So that I can allow for mentioning, not others. She has come saying that these that persons refused to take up this matter. That I can allow, and not others.
My your Lordship prayer for listing tomorrow, your Lordship bail.
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 Okay, if bail, if you can, if less than 7 years,
Lord.
bails are permitted.
I have to approach the
Yes, yes.
This is lordship appeal. In appeal lordship, already 2 persons convicted and their conviction period over. And lordship, they were in punishment period lordship. For fine period lordship. What happened lordship? Already fine period also over, but one was in our central jail and other transferred to Borpeta jail. Borpeta, our jail released the person day before yesterday. The other person did not released by the Borpeta jail because of pendency of this appeal. That is why lordship.
That cannot be okay. Listed. If you want to do unlisted, I can give permission today.
Obliged to lordship. And
The person should not-
another one is lordship next week any day lordship.
May I play your lordship?
Yes.
I am the item number 22. I am the respondent number 2 with the consent of the other side.
Yes.
With the consent of the other side, kindly allow me 3 weeks time for filing affidavit in opposition.
What is the criminal? I do not understand why affidavit in opposition in criminal division. Either challenge to an order or to quashing. We'll have to see whatever available on record. Do not understand what is the concept of filing affidavit in revision. What will you bring? Facts.
In fact, actually this is a forgery case, Your Honor, Your Lordship.
You are for the petitioner respondent.
Respondent number 2.
Okay. Adjourn if petitioner given. Adjourn. List of the few.
May I please lordship?
Yes.
Regular bill for tomorrow, 3-year punishment.
Bail up to 7. All are permitted for tomorrow. Day after, it is not a problem.
Lord, and prayer for bringing on taxi service affidavit, my lord. Item 35 minutes.
Yes.
Obliged, highly appreciated.
May I please, your lordship, with the concern of the other side, I beg to mention item number 19, lordship. Kindly matter may be adjourned for 2 weeks, lordship.
Why?
Lordship, my senior is fever, lordship, viral fever.
You are for?
I'm for the respondent, lordship,
Okay.
on behalf of the.
Any interim order? Have you taken consent from the petitioner?
Yes.
Is there any interim order? You wait for your turn. Yes. Next.
May please, I beg to mention item number 48. Hearing matter, my lord, criminal appeal. My lord, I pray that this matter may be taken up in the next week, ma'am.
Item number
48, ma'am, hearing matter, criminal appeal.
criminal appeal.
Yes.
2011.
So next week, any date, my lord.
Huh?
Next week,
Refused.
any-
Prayer for adjournment is refused. Yes, next. Yes.
Lordship,
Yes.
Lordship, I beg to mention item number 10. Lordship, the engaged counsel is out of station. When the date may be fixed.
Refused. Adjournment refused. You be here.
May I please, Your Lordship?
Yes.
With the concern of others, that I beg to mention item number 17. My senior N. Hassan is out of station. Matter may kindly pass for,
Have you taken consent from the other side?
Yes.
Is there any interim order?
No.
No. You have a petitioner?
Yes.
Okay, on the prayer of the learned counsel for a petitioner matter then adjourned for 4 weeks.
obliged.
No interim.
May I please, Your Lordship? This revision has been filed.
Except notice nothing.
Your Lordship,
Sorry.
and I am ready to pay Your Lordship. May it be 3,000, Your Lordship, interim. I am working as a cable operator, Your Lordship.
We are,
I,
whether you are working as a cable operator or you are a sub-agent of cable operator, that is, the finding is that you are not a employee. You are having a sub-dealership. of-
no, Your Lordship.
That
I have,
will- that
I have
will-
annexed the, Your Lordship. Only Your Lordship, it is the interim, Your Lordship.
Interim shall be considered on the next step.
Your Lordship, tomorrow is the date in the law court, Your Lordship. I will, let it be only for 2 months, let it be for 3,000, I am ready to pay,
No,
Your Lordship.
you can pay 3,000, you can pay 5,000. Notice, or you want a rejection of the interim order. We are issuing a notice on interim. Option is yours. If you want to say that you want an
Yes, Your Lordship,
Reject.
No, please to issue the notice.
okay,
Your-
notice, returnable on give a date. September 20. Justice also permitted. Interim prayer shall be considered on the next return.
Obliged.
Both ways. Yes,
Obliged.
same. Same. order. Yes.
Impugn order has been passed, my lord,
Yes, where is the impugn order?
rejecting application filed under section 311 for recalling the witness for his
Just give me a minute.
recourse examination.
Just give me a minute. Okay, where is the impugn order?
Page 20,
Page
20.
where is your application?
Page 15,
Page
15, 1-5.
Where is the earlier cross examination?
Not available there.
Not available.
My lord, earlier on 10/12/2018, they have already filed one another application that was rejected.
Where is that?
Thereafter, my lord, again, my lord, that is my page 21. Your lordship may kindly come to 11 paragraph second, last portion, your lordship. On 10/12, my earlier petition has rejected the similar petition for recalling PW1 and PW for recall
Yes.
cross
Why
examining.
should we not?
At that point,
why
they
should
have
we-
not challenged that.
Why should we allow this application? Satisfy us.
Some
What is
relevant-
the ground for recalling an witness under 311?
some relevant question has been left out to be asked.
Can
So
that
the
be a
PW1
ground?
and-
Can that be a ground? When that PW1 and PW2 was examined?
In 2018.
Right.
First time.
All evidences are over by.
Yeah.
So you argue your case. Satisfy us.
Just only PW1 and 2 are to
No,
be.
that cannot be a ground. Only PW1 and why should we enter? Why this order is bad?
Earlier council failed to remind all the questions got to be asked to PW1 and 2, and the newly engaged council find that some material question are left out.
After 6 months, a new council, you may call Horace Salve and Salve will say, no, these are not good questions. You ought to have asked this question. Then hard. You are Mr.
ABC.
ABCD, Learned Council for the petitioner. Also hard, Mr. Borthakur, we are dismissing a bit. Learned Council for the present application is filed under section 482.
No, criminal
The present revision petition is filed assailing an order dated 10/12/2018. Isn't it? 10/12/2018, 5 दिन, session case number 2022/2018. By the aforesaid order, the learned session judge or additional judge?
Relation.
Session Judge Bilasipara. Session Judge Bilasipara has rejected the application filed by the present applicant under section 311 for recalling PW1 and PW2 for cross examination. Full stop. The ground for such calling of the witnesses is that the earlier two counsel has failed to cross-examine PW1 and PW2 properly and had failed to put certain questions which are very necessary and vital for the determination of the case. Full stop. The learned court below, while dealing with the section 311 as well as fact of the case, rejected such application. The rejection of such application can be summarized as follows. The evidence of PW1 summarized as follows. 1, 2, 3. The evidence of PW1 and PW2, PW3 and PW4 were taken on 17/9/2018. And in the meantime, all witnesses were cross-examined by two counsels on 17/9/2018 and 18/4/2018. Full stop. Next, the PW1 is not the informant of the case, and PW2 is the informant of the case and has already been cross-examined in details on the point of Azahar. the court scrutinized after the court after scrutiny of the testimonies of the PW1, PW2, and PW3 and PW4, and after perusal of the Ezahar, did not find any just ground to recall PW1 and PW2 for cross-examination. It was an opinion of the learned court below that the evidence of PW1, 2, 3, and 4 are sufficient to arrive at a just decision in the case, along with the testimonies of the other solicited witnesses, including IO of the case. And there is no necessity to call the PW1 and PW2 for cross-examination. Full stop. This court the just a minute. The Honorable Apex Court in the case of Natasha Singh versus CBI within bracket state reported in 2013 5 SCC 741 held that the basic purpose of exercise of power under section 311 is whether calling of a witness was necessary for a just decision of a case. Just decision of a case. This court has also perused the order of this case and considering that already all witnesses were examined and the learned session judge has came to a conclusion after examination of the aforesaid witnesses as well as the evidence of the IO that there is no necessity to cross-examine, re-cross-examine the PW1 and 2 to arrive at a just decision, comma, this court finds no illegality in the aforesaid order to interfere with the same in exercise of its power under section 482 of the Code of Criminal Procedure. Accordingly, the present application stands excluded.
Maybe taken for the time being or something.
May I please?
Yes,
Respect 482 petition
yes.
on the ground that my lord, I have stated that I am a student of my lord 4th semester anthropology under Guwahati University,
Yes.
and my lord senior gang, they have planned. Last year also I could not sit for examination because of security concern. They have threatened me that since I am not abiding their rules, that your career will be spoiled and you could not sit for examination. And this year also they have, in a pre-planned manner, my lord, on the evening of my lord 13th, they have tried to kidnap me from the nearby area of Sundarburi, Guwahati University. Since they could not kidnap me, then they had handed over to the patrolling police patrolling party, and yeah, I was brought to the police station, and subsequently FIR was lost. Now, this is the FIR. FIR kindly find at page 13.
Yes.
May I read?
So this is the FIR you want to cause.
Yeah.
Where is the FIR that you have been beaten up, then you have been taken to custody? Where are you?
I have my father has lost a counter FIR, but that has not been my register. That is the problem. I have stated
Now,
categorically.
what is the parameter to exercise a power at the 482
My lord,
to pass an application?
my,
Pass
my-
an FIR?
my humble submission with that, my lord, can you find the reading of the FIR? It
I
is,
have
my lord,
already read it.
it is, my lord, a backdated, what is, my lord, incident was happened on 24th May 2023, and the FIR was lodged on 13/6. That means, my lord, after 20 days. So, my lord, Honorable Supreme Court has held in numerous cases that delay, it is not a fatal to the FIR, but that should be plausibly explained. But here, the delay has not been
So
explained.
that is a ground of quashing.
Yes, my lord.
Okay, so as a judgment that
My-
because of delay,
my lord.
FIR can be quashed.
If it is explained, then no problem.
No, no, if it is,
Yes,
if
yes.
it is not explained,
Yes,
FIR
yes.
should be quashed.
Yes.
Okay, so
Hello, in
which paragraph?
this Kishan Singh case, my lord, paragraph 21 and 22, can you find?
21 and 22.
May I read, my lord?
Good.
Prompt and early reporting of the occurrence by the informant with all its vivid details gives an assurance regarding truth of its version. In case there is some delay in filing the FIR, the complainant must give explanation for the same. Undoubtedly, delay in lodging the FIR does not make the complainant's case improbable when such a delay is properly explained. However, deliberate delay in lodging the complaint is always fatal. So my point is here.
Hmm.
In cases, para 22, in cases where there is a delay in lodging an FIR, the court has to look for a plausible explanation.
What is the
For-
subject matter and issue in this judgment?
My lord.
What is the background fact in this judgment?
My lord, mainly here, prosecution case,
Hmm.
my lord. The defense argument was that delay was,
What is the background of this case where this has been said?
My lord.
What was the prayer and what is the facts of this case in Kishan Singh?
can you find, my lord? Mainly criminal proceeding was thought to be quashed, my lord.
Why?
Since
On the ground
this-
that there was already a civil decree.
My lord, that is, my lord, not actually fitted in this case, but the motto is
If
there.
not fitted, why are you relying?
No, my lord, motto is there. Motto is that I am just pointing out that motto, that the FIR. When FIR is lost in a delay, belated, and the explanation is not given there,
Hmm.
probably that is, my lord, a concocted of facts, and that have to be, my lord, this is the onus of the planet go to my lord to see whether this is a miscarriage of justice or not. And I have referred another case law, my lord.
Now, my lord, from the contents of this FIR, my lord, this is not a fit case that this is to interpret.
Let him argue.
Yes,
You want to rely on judgment.
Well.
Let him have the happiness of.
Yes.
Yes, next case.
Well, next case is
Because you are dismissing it at the motion stage.
I have given para
Yes.
8, my lord.
Of
It is, my lord, NB Ramana case.
NB Ramana, it's not NB Ramana case. This case is P. Rajagopal and others
Yes,
versus
yes,
state
yes,
of
my lord.
Tamil Nadu.
Sorry.
NB Ramana is the
Yes.
author of this.
Yes,
Yes.
sir.
Next.
So my lord, here also,
Which paragraph?
para 8, my lord, kindly find.
Mm.
May I read, my lord?
Mm.
Normally, the court may reject the case of prosecution in case of inordinate delay in lodging the first information report because of the possibility of confusion of evidence by the prosecution. However, if the delay is satisfactorily explained, the court will decide the matter on merit without giving much importance to the delay. The court is duty bound to determine whether the explanation afforded is plausible enough given in the facts and circumstances of the case. The delay may be condoned if the complainant appears to be reliable and without any motive of implicating the accused falsely. So, my lord, my humble submission is that in the FIR, nowhere, my lord, it is mentioned that why she delayed. Because as per allegation that incident was happened on 24th May, but she lost this FIR on 13/6
20 days delay.
after 20 days. My lord. So she knows whether it is a, my lord, under pressure given by the this I have said my senior gang. They have brought up this lady to falsely complain against me and to destroy my life, destroy my career. And on the I have recently, my lord, through communication, email communication, I have been asked for appear to appear before the disciplinary committee of the Guwahati University. So, my lord, in a sense, my lord, double jeopardy maybe. It is, my lord, it is criminal case is already, my lord, long, and also there is, my lord, disciplinary action also I have to face.
It is Visakha committee.
My lord,
Okay. That's all.
my lord.
Heard Mr.
SC Das,
SC
SC Das.
SC Das, Learned Council for Appeal. Also heard Mr. Kothapur, Learned Council, Learned Additional Public Prosecutor. The present application is filed under section 482 for quashing an FIR dated 13/6/2023 lost by the respondent number 2. Is she a party here?
My lord,
Respondent number?
2, my lord.
Yes.
Yes,
Respondent
respondent number 2.
Respondent number 2. Please close the video. Were acquitted.
Yes,
Now,
and
what is the law in this regard?
my lord, insofar as the law is concerned, it cannot be an universal application that if other co-accused are acquitted, then the accused.
No, what was the ground of acquittal?
Yes, my lord, your lordship kindly takes up the judgment of the learned trial court, which starts from page 29. And my lord, I will straight away point out the relevant part, my lord, which perhaps.
Whether it was a case of that the other acquitted persons are not involved.
Yes.
If it is kind of that case, or that there was no evidence at all of a murder.
I'll just point out, my lord.
Yes.
Page number 38,
Yes.
paragraph number 24, page number 38, my lord. May I read?
Yes.
Upon careful
Yes,
telling.
what is the latest? Please the trial.
Yes, my lord.
Yes.
They will, because otherwise, my lord, paragraph page 7, paragraph 11, your lordship, they have stated that, my lord, they are not at all aware about the case. Since here in the year 2009, they have obtained a certified copy of the judgment. They are fully aware about that, my lord, that judgment, my lord. Thereafter, also
Okay.
till now, they have not appeared. my
Will
lord.
appear according to quest. Amit a negative disclosure put and apply for bail. Court will consider on its own merit.
And my lord,
Till then, the NBW
oblige,
will remain.
deeply
Amit to generate later.
obliged, deeply obliged.
Disclosure. Mr. Kolita, Learned Counsel for the petitioner. This is an application under so and so. Notice returnable on returnable on after 6 weeks. 25th of September, considering the material available on record as well as the allegation made in the complaint. The further proceeding of
CR case, my lord,
case number
133, 2023, my lord.
which
Jorhat, my lord.
shall remain.
Mat-
Non appears for the petitioner at list of the tweet. Yes,
Yes,
what
Lordship.
happened to your senior? What is your name?
Lordship Aring JP.
Huh?
Aring JP.
RMSR NJP, Learned Counsel for the petitioner. Also heard, are you represented, Mr. No, also heard Mr. Borua, Learned
Arjun Borua.
Additional Public Prosecutor, appearing for respondent number 2. Full stop. Issue notice returnable after 6 weeks. To as Mr. Borua accept notice. As Mr. Borua accept notice, no formal notice need be issued. However, extra copies be given to him. Steps in for issuance of notice in respect of respondent number 1 by both phase, considering the matter in entirety and the pleading made. The what should we say? This is the difficulty. You ought to have read the file at least. The senior said take adjournment of till shall return notice of further proceeding of CR case number 29C/2023 pending before the Learned Judicial Magistrate First Class in Sukia shall remain suspended. Yes, next case.
Apply.
CD interim within 10 days. Well, Mr. Borua.
My lord.
Huh?
My lord, only my lord, there are my lord FIR name accused, lord.
Huh?
The case of 379.
Arrested accused told our name. That
They are the laborer.
They are labor, definitely, that is why they have implicated the owner.
Let them, the problem is this, first of this, whether this FIR itself is maintainable. Because you say it to be Burmese supari. Moment you say Burmese supari, you don't have any jurisdiction. It will go to custom. Therefore, let them go produce whatsoever their documents. If nothing is there, if it is stolen, we'll reject. It will help your investigation if they appear and give their document. You produce.
Then interim lordship till returnable.
Till returnable. Till returnable. In the meantime, the petitioner shall appear before the IO and get their statement recorded and also furnish. Will not say they may not clear not on us.
Date maybe.
Okay, give a date.
My lord, 8/9 lord.
8.
I love that.
Yes, where is your FIR?
page number 10, man.
Absolutely bogus case. City interim.
No, he has given the first FIR. That I have also seen.
Absolutely bogus. She went to with him to that. Let us not discuss all things. Interim when
My lord, the 15/9 lord.
59 get your statement recorded within 10 days.
Apply.
Yes. Yes, have you filed the affidavit?
No,
No,
madam.
51. 53.
That is 50. 51.
Call for it. Yes, 50.
At 0.
Yes, lordship, I filed the affidavit, lordship.
Okay, we'll capture it. Let us call the 50. He has already called 50. 51. 51. Notice.
My lord.
Notice only. 2000.
So far as warrant part, fine. I'll go and I'll make a statement.
Huh?
Warrant has been issued.
Huh?
Warrant has been already issued against me.
Why warranty issue?
Because my lord, there are some
Pay. How much you have to pay?
my lord, area is 1,78,000.
How will you pay? Tell us.
Actually, my lord, my case is that my lord, the petitioner is 64 years old. He is also suffering from PTSD. Only 4 months was there.
So your best place will be government's house.
My lord,
They will give free treatment,
He's
free
also-
food, everything. Go there.
I will appear, my lord, and
Go
I
there.
will.
Go there. That's the best place. You are
Well, it is-
64 years. You are having ailment. You will get. We will observe that. Give him the proper treatment. We have heard that we had some visit to those places, and food are also good nowadays. So be a government guest.
Kindly consider.
That is you are considering for your benefit.
No, my
On
lord,
distance one only is Lord.
this is what.
The police
And
will
if-
not arrest those if he is not paid.
So, my lord,
And he can pay it in part also. It is not that he have to pay the entire amount.
my lord, I will definitely pay, my lord, because I know that when I have to appear,
When will you pay? Definitely within which period? Tell us.
my lord, within
We
15 days,
record it
within 15 days, my lord.
within 15 days
We
total
we
amount.
will appear before the landed court, my lord.
And then
And then we will settle the matter on any terms and condition as
oh
may
no,
be.
that ifs and buts we cannot pass. You tell us what is the area? 1 lakh.
1,78,000.
How much will you pay immediately? Have your instruction with the client and come back at 2.
My lord. Of that.
Or advise your client that instead of paying, you may go to have and get your treatment in the government.
No, my lord, I
Yes.
shall not definitely have that advice.
Yes.
Or like,
Yes, I Talukdar, part of the I Talukdar is to notice returnable forfeit in the meantime. List this matter on, give a date next week or thereafter. Jimma,
My lord, in the middle, repeat,
will
the
bring a
vehicle is in Jimma in my custody, my lord.
then
Thereafter, the learned additional district and session judge directed the opposite party number 2 preferred an appeal before the additional district and session judge Dibrugarh. After perusal of records and hearing both the parties, this court has passed the order directing the judicial magistrate first class to hand over the vehicle to the petitioner.
already handed over or not?
No, not handed over, my lord. Because I am the owner of the vehicle. The board,
How do you know? How do you say that you are the owner?
my lord, my vehicle is there, but I have already annexed all the documents. It is,
Now,
I
where
can't-
is the impugn order?
my lord, impugned order is page 60.
Page 60.
Operative part is 69.
Where is the finding 69?
Yes,
We do not want operative part. We want where is the finding that reason for giving Jimma to the other.
my lord, the reason for giving, my lord, kindly have a look of this page 67.
Page 67, yeah.
There are 12.
No. Paragraph 14, court says that ought to have been given. Where is the reason?
One reason is that, my lord, the up-to-date development was not produced before the learned addition session judge. That is the reason. Otherwise, my lord,
No,
up to the
Mr. Talukdar, you just show us the reason in the order.
in the my lord, in the order it is there, my lord.
Where?
Page 13, if your lordship kindly have a look.
Page
Page 68, para 13.
These are the law
Yes, ma'am.
discussed.
Yes.
Oh, what is the power under 397? What is the power under 401? What is the power under 482? Then at paragraph 14, court
Next
came to a
15.
conclusion that wrongly given custody. Why wrongly? Where is the
My-
reason?
Man, it is not wrongly, Mike, because I am the owner of the vehicle. That is my claim.
Lordship may page 62, Lordship. Para 3.
I am the owner of the vehicle.
No, we know that. we assume that you are the owner, but we want to see in the order what is the rejection or setting aside the order of the magistrate who has given you the Jimma. Where is that? Yes, Mr. Purva.
This is the my lord, why my lord,
Page, paragraph.
page 62 paragraph 2, why the my lord custody of the vehicle was granted to the opposite party.
There, who was the petitioner? The
Petitioner-
petitioner claims that she has bought the vehicle from him.
Yes. Let the
Can that
notice-
be a ground to give her a Jimma? Can the court determine all this? Who is the owner?
The notice
Court
is-
is to see who is the registered owner.
My lord, kindly have a,
Part, Mr.
my lord, kindly have a look at order dated 8/7/2022. Page 32. Installment is paying by myself. The vehicle is mortgaged in by the bank, my lord.
According, he is the registered owner, there is no dispute
Yes,
on it.
my lord.
Only question is that according to the other respondent, where is respondent number 2?
True.
According to respondent number 2, the C has purchased it. So therefore, it is a wrong order. Third, Mr. Talukdar Learned Counsel for the petitioner. The present application is filed. The selling order dated 20 notice returnable on given date 31st of only after 4 weeks, 26th of September. 2022. Considering the fact that the petitioner is the registered owner, comma, the impugn order dated 2020, whereby direction was issued to hand over the possession of the vehicle in question in favor of the respondent to the respondent number 2 shall remain state.
You have filed the affidavit, lordship,
Yes.
and their lordship 10 lakh rupees from lordship.
Show us that. Where is the affidavit?
I've given one copy.
Where is the affidavit? This is not on record. You have not called also. Yes, Mr. Burwa, give your copy. You ought to have called it in the morning. It was your duty to go to whether affidavit is on record. When have you filed it? Because yesterday was a holiday. Yes, show us.
Yes, lordship.
Show us.
আপনি দেখা হবে
Show us. Where is your affidavit? You are also not having.
I have filed, lordship, on the last question, lordship.
You have filed. Where is your copy?
I have given to the
Public
Yes,
prosecutor.
yes,
You have not made a mention that it should be called.
yes, lord.
Okay, call the affidavit.
Because on the last question, lordship is not filed.
Call the affidavit and list the call at 2. You ought to have called the affidavit. Give us the.
All right.
And give a copy to Mr. Borua in the meantime.
Yeah, please, your lordship, 439 application, lordship. If you
Arrested
are
when?
CD not
Arrest-
available.
Arrested when?
arrested 26, produced, but produced on 27, lordship. 26/7, lordship. Produced before the honorable CGM court on 27, lordship. So here allegation was that I had stolen the vehicle. I am the driver of the vehicle and the informant is the Informant is the owner. Along with him, we went to
When have you arrested?
arrested 26/7, Lordship.
26/7. To the satisfaction of
CGM Kamuru,
TGM Kamrup
Metro, Lordship.
Metro. 25,000.
Obliged, Lordship.
Yes, cities received.
CD not available. Updated CD was called for.
Non-appears to the account list. Update cities there. Yes, diary. All 40 also. Okay, so what is his role? Tell us.
Milord,
What is his role?
CD is not there, Milord, but
It is not.
not there, Milord. Updated CD was called for whether he appeared or not. Milord.
When.
Milord,
This is AP.
Milord AB.
Huh?
AB, Milord.
Any interim?
Interim is there as per in the note in the petition, Milord. Interim granted on 10/5.
Okay, non-appears for the petitioner account. Please next week. In the meantime, updated city. Give a date next week because you'll have to call.
The CD is there in 28.
No, earlier.
Oh, earlier, Milord.
Earlier, give a date.
15 months. In interim, master, they did work.
Interim, we are not extending in absence of the.
Okay.
Yes, what about it? It
CD is there, Milord.
Okay. Yes. It is there, na?
Yes, CD is
Wait for some time. Maybe people are thinking that will take admission first. Give a notice. Hey. Huh? Name not shown.
name not shown.
Any interim?
Milord, interim is there.
Okay. Register to list this matter showing name of the learned counsel for the petitioner. In interim order. List this matter next week. Give a date.
Next week.
25th. Interim order.
CD may be written, Milord.
CD may be written.
CD not able.
Any interim?
Milord. It is not stated in the petition, Milord.
Just any interim order?
Interim.
When interim order was passed? Huh?
Interim is
No,
not
there
there.
is not any interim order.
No interim order. Okay. When?
We're 24.
24. City call for.
20.
Madam, CD was called for as an interim.
CD not
Section is
received.
379, madam. I must grab it.
No interim.
No interim.
City.
CD not available, Milord.
Okay. When?
From Karbi Anglong, Milord. For 25th.
25th.
24.
Yes. It
City
is
not
there.
available, my lord.
City not able, interim to continue.
Dip-
Give a date.
1st September. my lord.
First September.
dip level.
Did you receive?
Not received, my lord.
No interim to when?
Kamrup Metro, my lord. 25th, 24th, sorry. my lord.
24.
May I please, Lord?
Did you receive, Lordship?
Sitting with injury report was called for, my lord.
Yes, tell us.
My lord, FIR at page 8, my lord. My lord, as per FIR, my lord, hand and backbone was broken, my lord. So serious allegation, my lord.
Serious.
My lord.
Yeah, previous injury, Lord.
Grievous.
Statement of witnesses, Lordship, also implicated, Lordship, and also the statement of victims are available.
My lord, there are three petitioners, my lord. One is, my lord, women, my lord. My lord, regarding whom, my lord, allegation is
What
there.
was the name of the woman?
My lord, Noor, my lord, Noorful Begum, my lord.
No.
Nurful
Noorful Begum.
Begum. Let us
Petition
see.
number 3, my lord. And petition number 2 is, my lord, Purban Ali, my lord.
Hmm.
So regarding whom, my lord, allegation is there, my lord, that may be considered, my lord. Specific allegation, my lord, not vague, my lord.
What is specifically? You have
Both have
joined,
inflicted the
Witnesses
body
Witnesses
injury.
implicated the three petitioners.
ah, you have joined together.
My lord, one thing is that, my lord, regarding land dispute, my lord, both party, my lord, entered into, my lord, non-litigation and
But in injury is of whom? Are you injured? Have you lost any affair?
my lord.
Huh?
My lord,
Tell
that is
us
not-
that I am also injured. We'll call your injury report. We'll see your affair.
Lord, that is right, my lord. So, my
If
lord,
that is
regarding, my
right,
lord,
we'll be right in rejecting your bill. Anyway, we'll see regarding the involvement. What are your names? Tell us.
my lord, petition one is, my lord, Abdul Jalil, my lord.
Yes, specifically named.
Number 2, my lord, Purban Ali.
Urban, specifically named.
Number 3, my lord,
Nurful
my
Begum.
lord. Lady, my lord, not so physically strong to inflict previous injury, my lord.
You are a part of a gang.
My lord, consider, my lord, at least, my lord, regarding women, my lord, consider, my lord.
Be together. Be together.
But kindly consider, my lord, women, my
Be
lord,
together. Why alone? What will you do?
my lord, humble prayer is that, my lord, regarding women, my lord, only consider, my lord. And other two, my lord, I do not, my lord, place, my lord.
Not only the injured victim, others also.
Yeah.
Peruse the city has called for the injured victim as well as the other cases seriously implicated both these three accused petitioner full stop. Also considered that the injuries are grievous in nature. Considering the above, this court is of the view that it is not a fit case to grant privilege of clear head. Accordingly, the present bail application is rejected.
Regarding, my
that
lord,
is-
petition number 3, my lord, kindly consider, my lord. Ladies, my lord,
We have
women, my lord,
considered.
he has
I
to, my
use
lord,
the word considered.
he has to see her, my
In
lord,
the
children,
considered opinion, this is
my lord,
not
she has
a
also
fit
to see her
case.
children, my lord. So that is, my lord, humble prayer, my lord, kindly consider, my lord.
Sorry.
Regarding petition number 3, my lord.
Sorry. She also went to the field. Everybody
district,
says,
my lord,
she also went to
injury,
the
my
field
lord.
with lathi.
And whether my lord backbone was broken or hands were broken, my lord, all these things are not.
This is not a case of privilege. I always say 438 is a privilege. Yes, next case. Yes.
Lord, the small
What
issue
you
in
want to be cost,
beg me
whole
pardon.
proceeding. You want to cost the whole proceeding
Who are the petitioner, my lord?
for a petitioner.
Yes, ma'am.
What is your, just tell us, summarize it, what are the grounds for doing that?
Ground for the quashing, my lord, for limited issue involved is compliance of section 17A of the Prevention of Corruption Act. My lord, the legislature in its wisdom
Hmm.
thought it prudent to insert the specific provision. Specific provision was inserted in the enactment, considering that there was a policy paralysis
What
in the
is the
government.
allegation against you?
My lord, that is I am at wit's end to understand. The allegation against me that I allowed release of bank guarantee. I sanctioned release of bank guarantee.
Hmm.
And the second allegation against me is that I passed the bills,
Hmm.
which I have not done.
Oh, that is a matter of time.
That is matter of trial, but that I have not done. My lord, as per they have no evidence that the bills were
No,
cleared by.
at 482, we are not going to look into
So
this.
limited issue is that something that I have done in exercise of my powers vested with me
Therefore,
as an official.
to have a sanction under 17A, what is the action that they have alleged? What are the actions? Let us know that. What is the allegation? Whether you have done it or not done it will be a different issue. Suppose the action are as such that a sanction is required, we'll issue a notice and say. So, and if your actions are such that it cannot be said to be in furtherance of your duty, then we'll only issue a notice. That's all.
That's right.
So therefore, you tell us the allegation.
So, my lord, the allegation is
Don't argue that these are incorrect allegations.
No,
We'll
no,
have to see at a
yes,
whether
yes,
prima facie, yes.
yes,
Tell us what
whether there is allegation. Now, my lord, see what had happened. There is a agreement entered into between NHI and the contractor, my lord.
Okay.
And my lord, as far as the contractor is concerned, he is awarded 450 crore rupees something contract. I am not the person who is executing that contract, my lord.
Yeah.
So it was executed by the head office. And their wisdom, they realize that this is the work worth so much of money. Now, my lord, then they appoints an engineering consultant.
Hmm.
That is, my lord, a consortium of a company. They are assigned, they are given the task for 9 crore rupees that they will monitor the day-to-day functioning.
Hmm.
They will monitor they will recommend the release of money bills stage wise, and that is how authority engineers came into picture. They were given the task. I am RO, I am regional officer. My task is to look compliances are done properly. And Lord, it is not the only project that is within my purview. There are more than 50 projects that I am supervising. Now, what happens is the CBI arrests 2 officials of my department, NHI. 2 officials are arrested, red-handed. On date is important, my lord. On 12/6/2022.
13, if I'm not
12/6.
arrested on.
Yes,
12/6/2022.
Yes. Arrested taking bribe.
Taking bribe.
From?
Two officials from the contractor, my lord.
Okay,
One from the officials of the contractor.
okay.
So now, my lord, that memorandum is I have placed on record.
No, we believe it.
Yes.
That they have been corporate-handed taking bribe. Okay, now?
There is no allegation against me that I was involved in any of these transactions or that bribe was accepted or taken for me or I had anything to do with it.
Okay.
Now they say on 14th they arrest me.
14th of
14th of
14/6.
14/6
46 2000. Yes.
on the basis of co-accused statement.
No, my lord, not even the co-accused statement. Somehow they think that since my junior officers, there is no confessional statement also per se of the accused. Of the so
Anyway, okay.
Anyway.
On the basis of their arrest, you are also arrested.
yes, I am also arrested. Now, my lord, as far as the transaction of taking or accepting bribe is concerned, that is over.
That's why I'm asking, what is the allegation written in the FIR or charge sheet against you?
FIR I am not named, my lord.
Then what is the materials against you in charge sheet?
Then in charge sheet they say that I misused my official position
Hmm.
and got a favorable report.
Hmm.
And on the basis of that favorable report, I released the bank guarantee.
One thing my learned friend is not disclosing. Not only that, he secured the job of his cousin on the basis of the release of the bank guarantee, lordship. He has taken an undue favor, lordship.
No,
It is there in the chart sheet,
to
lordship.
understand, job where?
Job in the company of the accused, private respondent.
You need a sanction, 17.
17, lordship, let me
Yes.
submit, lordship.
Hmm.
What is 17, lordship? 17 is that a police officer cannot investigate a case if the offense is relatable to a recommendation made or a decision taken by a public servant
Hmm.
in discharge of his official duty
Hmm.
by the appropriate government.
Yes.
That is section 17.
Hmm.
Here in this case, there is no decision taken by the accused, lordship, regarding the
What is the offense made out against
offense
you?
is with regard to the demand of bribe,
Where is
undue
that?
advantage, lordship.
Where is that?
It is there, lordship.
Where
Their
is the source
telephonic-
the FIR?
No, FIR they have not annexed, lordship, but in the charge sheet I have specifically mentioned.
FIR is important. We will not say that on the basis of FIR everything is to be decided.
Right, lord.
But where is the FIR?
FIR is there, my lord.
No, they have not annexed the FIR,
No,
lordship.
we have.
Here in this case, lordship, what section 7 has been amended, lordship. Earlier it was only pecuniary advantage. Now 17 is undue advantage, lordship. Now it is not only confined to pecuniary, lordship. Any undue advantage. Here in this case, lordship, the accused has taken undue advantage for releasing the bank guarantee, and that undue advantage is with regard to the service of his cousin brother. That apart,
Show us the material.
yes.
Show us the material.
material, lordship, your lordship will to call for the record then, because
Here,
statement,
what have you annexed?
statement,
On page number 6,
What is
33.
the stage of the trial?
It is, my lord, this copies of documents are served and now, my lord, I understand tomorrow matter is fixed for argument, though argument on charge. So it will not be possible at because
So if it's an argument of charge, why don't you argue that at that stage
no, my
and
lord,
come back to us? We will
no,
be
my lord,
better equipped
no, my
to
lord,
give you relief.
I have one difficulty, my lord.
What is your difficulty?
My difficulty is, my lord, today I am at verge of my promotion. I have, no, my lord, there is not, I will demonstrate, if my lord will have the records, I will demonstrate that there is not an iota of evidence against me or not an iota of allegation against
What
me.
kind of, we need the scan copies?
lordship, there is telephonic conversation between the accused and the private respondent. I mean to say the officials of the
You have that transcript.
transcript. Have to,
You'll, in the case diary, you will have the
yes, yes,
transcript.
yes, yes.
So you'll call the scan copies of the case diary. What
Yes,
is the next date of
telephonic
the case?
conversation may be called for, lordship.
Yes.
Next, I'll have to take instruction when the next, I have no idea.
Huh?
When is the next?
What is the next date?
Tomorrow, my lord.
Tomorrow, let tomorrow go, then there will be a date. We are not staying anything. We are not
No
staying.
difficulty, my lord, no difficulty.
We are just calling the case diary. So let us see what is in the
Yes,
case.
my lord.
But my view is that why don't you do that?
No, my lord, there is
During the
difficulty. I
charge.
am at, my lord, it will take ages for the London trial court to, because 10 accused are made
the documents are 15,000 pages of documentation, and my lord, it will take me for ages. And I am incarcerated. I was incarcerated. The learned, this
Okay, we are not issuing a notice, we are just having the scan copy.
Can
When-
copy of the telephonic 280 something telephonic conversation has been intercepted by CBI on the basis of source information. There's lots of conversation between the private accused person and this accused person along with the accused of NHI. I mean to say GR
But
conference.
it's to us the 17,
Lord.
17,
17, my lord. May I read?
yes.
17 is
17,
not
my lord. Inquiry
or
investigation of offences related to recommendations made or decision taken by public servant in discharge of official functions or duties. No police officer shall conduct any inquiry or investigation into an offence alleged to have been committed by a public servant under this act, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions or duties without the previous approval of, in the case of a person who is
Now
or
tell us, if he has wrongly released the bank guarantee, it was his official function,
no lordship.
isn't it?
Yes, lordship. But had that been the case that he has not demanded any money, demanded any undue advantage, matter would be different, lordship. Here in this case, there is a demand of getting his cousin to be recruited in this company, lordship.
Where are those
His
materials?
cousin has admitted, lordship. Statement of the cousin is also important.
So you are charging on the basis of his cousin's statement.
Cousin statement and telephonic conversation, lordship. There are lots of telephonic conversations.
Okay. So these are the two things
Yes, yes.
against him.
And that apart, lordship, some machineries of the private respondents, I mean to say accused company, GR Infrastructure, he sold it. He tried to sell it, and he demanded 50,000 from another accused person. So those are the allegations, lordship. He tried to sell some machineries of GR Infrastructure. GR Infrastructure is a company who has been entrusted to execute the contract work.
Who was the search sheet?
Lord.
Who was the search sheet against him?
yes, ma'am. Before, my lord, I just for a minute, my lord, kindly see the relevant contents of the agreement wherein the release of bank guarantee is concerned, my lord. My lord, I read step.
I want to first see the charge against you.
Yes, yes, ma'am.
Then will come what have you done or what have you not
Yes,
done.
my
Let us see the
Yes, my lord.
charge against you.
Yes, my lord.
Page
Page, lordship, 46 is the relevant start from 46, lordship.
46.
46 of the petition, lordship. It just start from the 16.1, lordship. Paragraph 16.1, it starts
16.1.
16.1.
This is against him.
No, it starts from 61. It's a very long search, lordship.
No,
Page number 47, lordship may
I
kindly,
am at page 46,
lordship may kindly specific allegation, let me come to 47, lordship.
47.
7,
Okay.
lordship. Paragraph 16.2.
Okay.
It was alleged that GR Infrastructure Limited was awarded the road bridge construction tender in the jurisdiction of NHI Regional Office Guwahati, and Sushil Kumar Verma.
He is Sushil Kumar.
Sushil Kumar is
Ah.
Lord, he was also arrested, lordship.
No. What is the name of this man?
This Alok Kumar.
Alok Kumar.
Okay, okay.
Sushil Kumar Verma, manager, Comtech project director, is monitoring the aforesaid work. Accused Sushil Kumar Agarwal, executive director of GR Infrastructure Infra Project Limited, is maintaining regular contacts with the officers of NHI for obtaining favor in the matter of processing and payment of bills, releasing of bank guarantee, etc., to corrupt and illegal means, with the help of accused Pankaj Singh, an employee of GR Infrastructure Limited. All the bills as well as the applications for release of two performance guarantee were processed by Sushil Kumar Verma from PIU Shillong to regional office for payment public release. Accused Sushil Kumar Agarwal requests himself to Alok Kumar. Here comes the role of the accused Alok Kumar. Alok Kumar, regional office so and so. Sri Pankaj Saran also to expedite the release of bank guarantee of MSGR Infra Project Limited, and got assured from Alok Kumar to get done all his pending work. Therefore, Sri Alok Kumar also conveyed to accused Sushil Kumar Agarwal that he had ensured that the authority engineer It's Authority Indians of Aegis Limited, Lordship. Authority Indians from Aegis India Consultancy Engineer Private Limited will recommend the release of bank guarantee worth 10 crores. And subsequently on 27/4/22, Pankaj Singh confirmed to accused Sunil Kumar Agarwal that one of the BG has been released by RO. RO is the Alok Kumar from the aforesaid one BG. Sunil Kumar Agarwal asked Pankaj Charan to apply for release of dual BG amounting to rupees 2.50 crores. And thereafter on 13/5/22, Pankaj Singh confirmed to Sunil Kumar Agarwal that 3 bills have been submitted to PIU and same will be forwarded to RO office for payment. So this is one of the allegation, Lordship. Lordship then may come to page number 48, paragraph 16.4. It is also alleged that despite of initial adverse remarks by Ashok Kumar engineers Aegis so and so for monitoring against the BG release, accused Alok Kumar assured positive report of Ashok Kumar Singh. So he assured, in spite of the fact that there is a negative report from the Aegis, Alok Kumar assured the accused of GR infrastructure that he will get it done to release the bank guarantee, Lordship. Then para 16.5, it is further alleged that apart from explaining the previous expenditure of bribe of 70 lakhs given to NHI officials, including accused Alok Kumar and Sri Sushil Kumar Verma, Pankaj Singh confirmed Dilip Rajput about receiving 26.61 lakhs at Guwahati and Shillong through Hawala channel. On being confirmed by Pankaj Singh about receiving one of the BGs, Sunil Agarwal instructed him to pay rupees 3 lakh and 50,000 to Alok Kumar. So specific allegation is there. And PD posted at Shillong for avoiding any further hurdles with assurance of arranging the aforesaid money in the next few days. So the specific allegation against him that they have given the bribe amount in rupees 3,50,000 to Alok Kumar for releasing the bank guarantee. That apart regarding the undue favor, apart from pecuniary advantage, that I will page number, Lordship, 61, I think, 61. Paragraph 30.6, page number 61. 61, Lordship.
Yes, sir. Paragraph
Paragraph 16.30, middle portion of it. Investigation disclosed that accused Alok Kumar, while being posted and functioning as regional officer, NHI Regional Office Guwahati, by abusing his official position as public servant, entered into criminal conspiracy with the accused person for ensuring the favorable report from authorities engineer of Aegis India Consultancy Engineering Private Limited and timely release of BGs by suppressing the questionable report of consultant. In furtherance of criminal conspiracy, Alok Kumar assured accused persons Sunil Kumar Agarwal and Pankaj Singh for timely and smooth release of BGs of GR Infrastructure Limited and obtained the undue advantage by securing a job for his distant relative in the accused company.
you bring you will have your record.
Lordship.
You bring the part of the case diary
Lordship.
which shows in support of this paragraph.
Lordship. Only two things is required, Lordship, whether there is a specific allegation against the
Yes,
accuser with
that
regard
must-
to the big
that
advantage.
must- Because subject to the next date's argument, his role, the consultant was supposed to given a role, given a report. Now he released the BG. Now this is a official execution, except the other part that you are saying that given. So let us show us.
That apart, Lordship,
Mm.
that bank guarantee ought to have been released within 60 days.
Mm.
They retain the bank guarantee.
Understand?
Lordship.
He has done that. Assuming for a moment that he has done that. But he has executed, this was his duty in discharge of his duty.
My lord, as far as the demand is concerned, my lord, at the time of his bail, there is specific averment by the Honorable Predecessor Court on his bail, wherein the Honorable High Court says that there is no demand as far as by this petitioner is
That's why
concerned.
we'll see that.
And then, my lord, the case of prosecution hinges on one.
That's why I'm saying you might have a very good case for discharge.
No, no, my lord.
Why don't you argue for
I-
discharge on the next day?
My lord, I say, we will demonstrate that it is absolutely good case for questioning of the proceedings, my lord. Why
Discharge is a kind of a causing.
no, my lord.
Why don't you come after that instead of bringing all
No,
those?
my lord, it will take, at least I understand, I have done, my lord, hundreds of CBI cases,
No.
and it takes at least 1 to 2 years for
it's a wrong-
special judge to finish off.
Now,
arguments on
this will not. Who is this? Mr. Sharma is there.
No, no, my lord,
Three
Mr.
special judges are there.
This
Please,
is
CBI.
being taken up by.
Taken up lordship. I have no idea, lordship. I have not.
These are very efficient officers. They will do it.
It is.
But you bring those materials
Lordship.
to show that it was not necessary. I am giving you the responsibility.
I'll bring some statement of this,
Whatsoever you to show
four
that
statement is
these
enough.
are the facts
lordship.
on the basis of which these are the conclusions.
Lordship.
Just we'll see. We'll not go. We cannot go in depth. We
Lordship.
cannot have
Yes.
Right.
minute trial. We'll show the materials on the basis of which charge has been
If
stamped.
my lord can have, give me 1 minute, my lord, I will show that what is there. They say that I ensured that the report of the.
Understand? That's
that
why we're
I-
asking.
I have next, my lord, that report. That report is
We
already on.
will go to that.
Yes, sir.
I want to give a chance to the CBI
Yes, yes,
counsel
yes, sir.
to show that these are charges against him, and these are based on these materials, and therefore his argument is not sustainable. That much. We'll not go to the others.
Well, I'll bring only the relevant.
Relevant, whatever
the
relevant.
statement of this. I mean to say the statement of the.
You can have a binded copy, give a copy to
Lord.
him, to me also.
Lord.
Then we'll decide.
Lord.
Prima facie, our view is little bit tilted in his favor.
Otherwise, lordship,
But
now,
this court will never make up its mind. After hearing you, will take account. So therefore, it's your specific responsibility to show that these are the charges framed against charges against him by the CPI, and these are the supporting materials. Show us those specifically. These are the points. These are the materials. Then we'll decide.
And also let
Yes,
it
give
place
it.
the transcript also, my lord.
Yes.
That transcript, he
We-
says.
Transcript definitely
Yes.
will bring it.
we have supplied them a copy. I
No, no,
think,
you have
in the file.
definitely, I did not burden this honorable court.
No,
because
you also have it. Whatever is in your.
Yes, sir,
in your-
that I will do, that I will.
When?
Can it be on 12th, Lord, September 12th?
12th of September.
12th of September.
We are saying it in keeping it in the motion itself.
Yes, my lord.
Otherwise,
Please.
lordship, there is no direct evidence as such.
No,
No
we know
direct
that.
evidence. Even
but-
then, lordship, if your lordship go through the transcript
Yes,
and
that
all.
you argue that.
Lordship.
We are open to arguments. No problem on that. No problem on that. Just we want to see the metal in support of your contention,
Lord.
so that even if we go in your favor, we can pass a reasoned order.
Yes.
If we go in his favor, we can pass a
Yes.
reasoned order,
Yes, ma'am.
because we'll have to give reason
Yes, ma'am.
either way. On the prayer of the learned counsel for the standing counsel for the CBI, list this matter on 12th,
So, lordship, let it be on 14th.
14th of
12th, I have
September
already fixed.
2023, on which date we will not say anything. Our understanding is that we will
To bring the record,
we
relevant record.
bring on next date, we bring the relevant portion of the records in support of the charges framed against
Right, yes.
The charges alleged in the charge sheet. my
in
lord,
the
not framed.
alleged in the not charges,
Yeah.
alleged in the charge sheet. Charges level in
Against
the
the-
charge sheet against the present petition.
Grateful, ma'am.
Value, Lord.
Bail we will not. Okay. ठीक है? Yes, what is this?
I am appealing for the opposite party.
Huh?
The appellant has filed this IA
Hmm.
for suspension of the for revision of the order, Lordship. Wherein Lordship, this honorable court, if your Lordship kindly takes up the IA.
Non-FPS for the petitioner on call, please, sir. So
Right.
the respondent number
Lordship, I'm
is
that's called it.
two is represented by Mr.
Eighth of October.
A. Chakraborty.
Lovely.
Where is Lord?
Yes.
Condonation of delay, my lord.
Delay in preparing
Criminal revision petition, my lord.
against
NI Act, my lord.
how much delay?
250 days, my lord.
Huh?
250 days.
So where the respondent, we file column number on 14/8, but our name is not shown in the cause list.
Condon delay.
Condon মানে actually,
Well, she is inside, my lord.
or maybe condon to be
We control
elaborately
the
not.
delay, ask the revision petition to be registered and list as per your convenience, asking the registry to list it showing your name.
Yes.
Can it be a short date, my lord, because she is inside?
Okay, give us a date.
Monday কি হবে না?
How much money? How much money is in?
Money,
Only.
5,75,000 awarded and
Give him.
That is, my lord,
concurring
enhanced, it
findings.
was enhanced.
Huh?
Enhanced.
Original হেৰি আছিল check amount is my lord 5,50,000.
Yes.
Thereafter awarded 25,000. Total into 5,75,000. The case is filed in the year 2015. Since then, complainant is
Come with, you are the accused. So come
The
with the instruction of your client to deposit something.
But that I'll ask my client.
You have your instruction.
Can it be a Monday, my lord, 21st?
Which are the paragraph? Pardon, Mr. Mahajan.
Paragraph, my lord,
Counsel should have petitioner.
3 and 4, my lord.
Huh?
3 and 4.
Okay, also heard, Mr.
Mr.
You are
S.I. Ahmed. My senior's name may be
Okay.
recorded and Ahmed.
N. Ahmed.
Yes.
Learned counsel for the petitioner. Peruse the explanation given at paragraph
3 and 4, my lord.
3 and 5, 3 and 4. The learned counsel for the respondent has seriously objected such delay, saying that the matter is being pending since
2015.
2015 and both the court has concurrently convicted the part. Consider the sufficient and also the explanation given at paragraph 3 and 4. This court is of the view that the applicant has been able to explain that
Delay.
the applicant has sufficient causes satisfying that sufficient causes explaining the delay in approaching. Accordingly, delay is condoned. Registry to register the criminal revision petition if not effective and list this matter on
Monday, 21st.
28,
Is inside, my
21st,
or 22nd.
22nd, 21st, 22nd of August 23, showing the name of the learned counsel for the respondent number
Two.
2, namely
Mr. N. Ahmed.
Mr. N. Ahmed and
Mr. MD S.I. Ahmed.
M. Muhammad S.I.R.
Obliged, my lord, highly obliged.
Very mad or at 1. Yes, next yes.
Please, your lordship.
Yes.
Lordship, this matter is placed today for consideration of IA 811 of the 2022, your lordship,
IA.
which is a petition under section 389 for consideration of
What was the
failure.
conviction?
10 years.
10 years, your lordship.
10 years allegation.
376.
We have
Where
filed
are the statements?
statements are there, your lordship, and there are contradictions as well, your lordship.
No, we'll go to the contradiction. Let us see the statement.
Right.
Why are you going straight to the argument?
Right.
Let us understand.
I have filed objection. PW5 is the
Where do you get the statement?
In the objection.
Have you annexed?
Lordship, in the objection they have filed.
No, you want bail.
Lordship, we
You
have,
want to say that there are contradictions.
Yes.
On what basis?
we have annexed in the main case. Your Lordship.
Yes, so ask them. You
Okay.
argue your case first, then we'll go to it. Where are the statements?
In the main case, Your Lordship,
Where is the FIR?
the statements are from page number 23, Your Lordship. Deputy.
Yes, what is this?
Lordship, I ordered it, 16.6 instruction was surfered from the respondent.
What is instruction? We have not recorded anything. Yes, Mr. Bokoto, what is this?
My lord, in fact, the petition appellant herein, the revision petitioner, has filed an application for enhancement of the maintenance of the Marina Stand.
Okay.
And the court, after hearing both the sides and taking evidence, has increased it from 10 to 16,000 rupees. But they are not satisfied, they want more.
Okay, what kind of instruction? We'll hear it someday.
And he's regularly
It-
paying, my lord, the enhanced amount.
Actually, Lordship, as per the Apex Court, 25% of the net salary is the
It depends
Which
upon case to
judgment?
case, my lord.
Which judgment? Which judgment?
Kollam Day.
Why this has come in the order column?
Lordship has indicated in the previous day that
Previously, the hearing,
since it is a very small matter, and if on 2 occasions has not reached, like since it was in the hearing list. That's why
Okay,
we-
this case has already been admitted.
Yes,
Not be today, but cannot be-
no problem.
If he's paying,
He's paying, my lord. Regularly the enhanced amount, he's regularly paying.
but the admission fees and other fees is the, I
Well,
am,
that
the
too also
petitioner
he
is
will
paying-
give. Well, after all, it
petitioner
is
is-
his son. It is not that his career is coming to an end tomorrow when he becomes major. If he studies engineering or whatever it is, the father is always supporting him.
but
And
the
every weekend he
the
come and
ad-
stay with the father only.
admission fees.
don't you have a settlement that you'll give him the education fee and or what?
That he is giving, my lord, clothes, food, everything, whatever. When he comes, he gives everything.
No,
And
the
he's
ad-
asking
ad-
for 25%, my
Lordship,
lord.
Lordship,
The thing is,
admission fees
you
and
should see
other.
his income also, how much he earns. And that too, he has a mother,
What do you do?
he is an assistant professor.
Okay, then how many children?
Only one, but he has remarried subsequently
Okay,
after the reverse petition was filed by the revision petitioner.
okay.
And he has also had a kid.
What is
Small
the
child.
age of the children?
Now it's
He's in around class 11.
Huh?
Class
Class 11.
Class 11. Around 6 and 7.
He is providing everything.
Okay, give a date mostly. Huh? No, we are, because of these judgments we are dictating in the second half, 11, 12. It's taking some time, so I do not want to add one more.
No problem.
Let me be frank. So again, we are having 2-3 hearing matters today. We are giving first preference to those old pending matters. Since you are paying,
He is paying, my lord, regularly.
that
Previously he was
this
paying
matter
10,000.
may-
But
And now
but
he's
the
paying the
admission
interest
fees and
amount.
other tuition fees also, we have he is facing financial hardship. But my career is the,
She's
What-
working, my
Huh?
lord,
What do you do?
in a private firm. She's
I'm
working.
working in the private.
Okay, we'll decide. We'll ensure that your education needs are
Yes.
taken care of till at least your education is complete. We'll consider that. You also have instruction. Even undertaking will close it. That will continue to pay it.
He's continuing to pay, my lord.
Continuing to pay.
He'll never
you'll-
stop paying.
You'll,
After all, it is his son.
you'll take his educational responsibilities. You have it in your instruction. Give a date. 28. Wait. 28.
Of
You
this
have.
one.
We are not passing in the order. You have your instruction.
This one, my lord.
So that you can give an statement, you can make a statement that yes, he will also take care of the as and when necessary it is admission fees. And you have an instruction. We cannot force, but you have your.
Much obliged.
What is the ground of?
My lord, in fact, I did not find any ground in the review. My lord,
Yes,
your
but
lordship.
Lordship,
the
Other council-
groundwork to go to the upstairs. This review is, I think, the groundwork to go to the upstairs. Isn't it? In the meantime, delay has been caused, so this is the groundwork to go upstairs. Delhi, tell us,
No,
what are the
Lordship,
ground?
Only the point is that Lordship, one ground we have taken in the appeal, that was Lordship heard thoroughly and it was decided Lordship. But the other grounds were not touched at all. That is, that was, so far as my part is concerned, Lordship, that was not considered.
Do not find any merit in this review petition.
And regarding
Go
interest
there, go upstairs, go
and
upstairs.
Lordship
Yes.
regarding.
We will not waste time on this.
Lordship already stated.
You have written all the grounds. I have seen.
No, interest on future prospect also in other cases, Lordship has that ground also considered.
This I have committed a mistake. They have dismissed it, go upstairs.
Master.
39.
That can be.
All dismissed, all review
That
petitions.
point at least Lordship, because Lordship judgment is there.
There, we'll say
That
that
point
that
on the
was,
interest on future prospect, that cannot be entitled. That
give
point
it,
may be.
give in this case, we will not waste time on all this.
Must
We
be-
are giving you everywhere. So
Not-
might be somehow it was either not ours or somehow it is
Yes, that
all
point.
review and onlet ground will not reopen. Moment we start it reopen, again we'll have to hear at the entire matter. Review means we'll have to recall the order. We are not finding anything to recall. You want to show some judgment?
Lordship on the one that.
Yes.
Here in this case, I is pending for prayer for bail and suspension of sentence.
What was the offense?
Offense is 376, Lordship.
Where is the statement? Yes,
LCR is
we
there.
file anything objection?
Their objection they have filed.
Okay, where do we get the statements and all?
That is in the record, call for record.
We expect that a person who seeks a bail
And
must be ready with, because moment we go there, the handwritings are so bad, we'll have to start the wastage of time. A person who seeks a bail must be ready with his paper book, with all the evidence.
here it is in
This is
English.
the expectation of the court. Of course, we cannot compel you. Yes, give the record. And this is more expected from young lawyer.
Will submit it.
If 376, no live streaming. Any offense against women? No live streaming. To talk of compromise fail.
My lord, in the meantime, we have settled the matter outside the court because he has also agreed, and we are agreement has been only in the meantime 4 installments have been paid within 9 with 9 installments we are going to complete.
You can close it.
I have
Any
no-
agreement with you?
Yes,
Agreement,
yes,
my lord.
yes.
Yes, lord. Yes, I kindly turn to page number.
That page number?
Annexer A. Oh, II application, my lord.
IA.
II application, annexer
Okay.
A, page number 8, my lord.
Okay.
The relevant portion, my lord. The
Page 8 of the IA.
the first party has agreed to offer total amount will be
Both the learned
91,000.
counsel for the party submitted that they have amicably settled the matter. Since the matter relates to financial issues and private is matter, the between judgments and sentence are certified and passed on the basis of the appropriate compromise. I dispose of criminal revision.
Habla.
Art Mr. Roy and
Miss Tiro.
Notice issue করেছে।
IA, IA cannot very in IA they have filed a brought a compromise. In accordingly the judgment in order, but in view of the compromise settled between the parties in terms of agreement dated. Yes, what is it?
Revision petition.
Yes, madam.
If some time may be granted.
To do what? Huh?
Test, test. Earlier,
You
notice was
press
issued.
steps or you have not taken any steps? There will be phrase when something is done already. They have not taken steps.
Yes.
So let us
That-
dismiss this for want of steps. The learned counsel for a petition not submit that due to inadvertence steps for issuance of notice upon respondent were not done. Accordingly, she prays that she may be granted 3 days time. When prayer is allowed. Please according.
Next one.
Wait, period.
Yes,
There are 76 days delay in filing this revision lordship.
first time listed.
First time.
Who is the other side?
Other side is the state lordship.
State
State
and
and
two.
response number 2.
Who is two?
Two is the informant.
What is the case?
Case is of rash and negligent driving lordship, and subsequently his appeal was dismissed and he was directed to surrender. But during the pendency of the appeal, he was not in contact with the engaged counsel lordship. So
Okay.
that stay order is or prayer is also there. Lordship. That may
IA allow. Paragraph?
paragraph lordship 3 lordship.
Huh?
Three
Paragraph
and four.
3.
Three and four.
Paragraph 3, 76 days delay. Then revision petition be registered if not defective and be listed on next month.
21.
21.
Alright.
May legal lordship.
Yes,
Your
Mr.
lordship can take up the
Mohan.
IA. My lord, for bail, my lord, conviction 10 years, my lord, under section 376, my lord. I have annexed, my lord, FIR as well as 164 statement, as well as my lord, statement of the victim and IO. There is no doctor examine here.
Where do you get those, all those? In the IA?
IA, my lord. In IA.
Law affair, personal problem. Whether, what is the case about?
304
304 part 1.
part 1.
10 years imprisonment. Your lordship, here I am in jail for 11 months. My bail petition was rejected. Here what happened, my lord? Only charge sheet and FIR is in Assamese. Other documents, my lord, all are in English. Now your lordship pass an order after rejecting my bail prayer that prepare the paper book. So paper book will be prepared in as usual manner, my lord. My problem is this, my lord. I pray before your lordship. I will provide the certified copy in translated copy of FIR and charge sheet, my lord. And in that case, my lord, everything will be in English. So first prayer before your lordship, my lord, the paper book may be dispensed to it. Only I may be allowed to supply this translated copy of FIR and charge sheet, my lord.
What is the order of paper book?
My lord, yeah, that is, I have annexed, my lord. That is at page 8, my lord. Registry is directed to list the matter for hearing immediately after preparation of the paper. So, my lord, it will take time.
We will have to issue notification.
My lord.
These are delaying the
Yes,
case.
not
So, my lord, my
Don't forget
humble
about
submission.
this.
I have two prayers before your lordship.
Have you filed any bail application?
Bail application already rejected.
earlier rejected.
Earlier
Already-
rejected.
Eyewitness was given.
All,
After rejection, my lord, this order has been passed.
yeah,
My lord, I have alternative prayer. If your lordship please, in that case, paper book may be prepared by me. Let the registry examine it,
you
and
do
if it
that,
is found okay,
you do that, you do
my
that.
lord,
Since
if-
there is a judicial order, but we have a discussion.
my lord.
I had in fact a discussion with my lord, Honorable Chief Justice. In single bench, it is not, as per High
Yes,
Court
yes,
rule,
my
paper
lord.
book is not necessary.
My lord.
These
If-
are delaying the matter.
My lord, in that case, my lord, I will supply this.
You since there is a judicial order, in this case, you supply the prepared
Yes.
paper book to the registry will verify and accordingly
It will be.
If at all not eligible, then otherwise, well,
this I is for that.
Yes, ma'am.
Third, Mr. Sikh Learned Council. This court under its order dated
23/5/2023.
23/5/2023 has directed to prepare paper book in this case. Mr. Sheikh submits that he may be allowed to prepare the paper book at his own cost and submit the same before the registry for verification, and the registry after verification may finalize the same, and such action will expedite the matter for hearing, as his bail application has already been rejected by the court. Full stop. The
So after preparation of paper book,
such prayer is allowed. The petitioner is allowed to prepare the paper book within a period of
month, my lord.
within a period of a month and submit the same before the which sector?
Criminal appeal section.
Criminal appeal section, and the section will verify the same, and if found correct, same may be finalized and a copy be given to the petitioner, the learned public prosecutor, and a copy for the court also. Full stop.
So, my lord, the date may take, my lord, after 1 month, my lord. Further.
You give release this matter after submission of the finalization of the paper.
Oblige. Mato.
I extend this disposal.
Only good.
Yes, Mr. Banik.
no, I'm for the other side, my lord. His complaint petition was dismissed for non-prosecution.
My complaint petition was dismissed for non-prosecution. Your Lord. The petitioner is a physically handicapped person. Your Lord.
Petition, your what petition? NI Act.
And I, Your Lord. He's a physically handicapped person. Your Lord. So I've annexed a physically disability certificate on page 22. Your Lord. He remains unwell. Your Lordship. On that very day, also he have filed an application.
In how many days you have done?
Lordship. Your Lordship may peruse the
Order.
order. Your Lordship.
Five.
Hmm?
Five. In the last occasion, the difficulty was on a different score. He has filed a revision application. With the dismissal of the complaint petition,
It should be an appeal.
it should be an appeal with leave petition being granted. That's a requirement, mandatory requirement.
Your
It is there.
Your
That is
Lordship,
there.
in the last hearing, Your Lordship, that thing has been taken care of, Your Lordship. And
But
Your
it's-
Lordship, the order with Your Lordship reveal, Your Lordship. Your Lordship, as per subsection 5 of section 401, Your Lordship. Your Lordship. It has been converted into an appeal, Your Lordship, as per subsection 5 of section 401 of CRPC, Your Lordship.
It has not been converted, number one. The order does not reflect so. And four, there are judgments to show that 4015 and 37, the requirements of 378.4 are different and distinct. If without the requirement of filing a leave application, an appeal can be converted, then straight away it will
See,
be converted.
one decision is, one thing is sure, you can take it that we are restoring the
Absolutely,
decision. That is for sure.
that is for sure.
That is for sure.
We are
Now,
saying,
what are the technicalities and how that can be removed? You advise us.
my God,
Forget about it.
if I
You
may place
tell us.
this- if I may place this order of this honorable,
Don't show anything. Mr. Bonik will tell us what course of action
then
this
he
court
has
should
to
do.
file an application, 378, along with that subsection for grant of leave, lordship grants the leave and
corrects it.
Okay, you file.
That's all. That has to be done. That's
But there is an order. How do you handle this?
what- I have read this order, if Lordship kindly order for copy of it.
The learned council has submitted that as per section 41.22, no order under film has been suspended.
I'll refer to that.
But there is no determination.
That's what.
Yes, the court recorded the submission, does not say that
Determination.
do it by
Absolutely.
next week, we are allowing a petition. Have that.
Lordship, I will file an leave petition.
You file a leave petition and also file an petition, no regret, anything is to be mentioned. File an application to convert this to appeal.
In that case, there are judgment of the apex court, my lord. 378 is a Lordship may allow that application, but filing is mandatory. Because unacquitted. The right of
Appeal is appeal, we also.
yes, sir.
Because dismissal will amount to an
Acquittal.
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 Moment it's acquittal, leave as well as appeal.
Appeal has
will
to be filed.
Appeal has to be filed. So what we are passing is that we are giving you the certified copy back.
He may withdraw and refile. That's a better way out
We are giving.
with the liberty.
Since you may I just suggest your lordship, since subsection 5 suggests that whenever under this code an appeal lies, but an application for revision has been made to the High Court by any person, and the High Court is satisfied that such application was made under erroneous belief that no appeal lies thereto, and that is necessary in the interest of justice so to do, the High Court may treat the application for revision as a petition of appeal and deal with the same accordingly. So if your lordship may treat this
Okay.
application as
You
appeal,
file an appeal, give us the profit.
your lordship.
My lord, I would like to place the judgment which
Subsection
says
5
in such cases where the acquittal has come under 256, then the provision of 4015 which is shown, that is different in case where leave is not required. But if leave is required,
Understand? You want
conversion
to
which,
say
which
under you to say how will you convert it to an appeal
without granting,
when the
Leave is not being
leave
granted.
is not granted? You are correct.
Your lordship, what I'm saying, your lordship, if this revision is converted in appeal, I may file an extra leave petition, your lordship.
See, now you what do you mean by leave? We may not grant leave also. So how
leave with
can an
confirmation.
appeal be exist? How appeal can an appeal
Absolutely.
exist without
So
granting
these
a
are
leave?
different circumstances.
So we want to help you. File an application of leave.
He may withdraw and refile. That will be easier.
That
Rather
will be
converting.
easier.
That will be easier. To be fair, it will be easier.
There may be some delay, but we'll give you the certified copy return back.
Lordship. Yes.
We'll ask the registry
And
to
continuance
give
of
you the
proceeding would be
certified
there.
copy return back, and you file an application that
Absolutely.
by mistake
Yes, yes.
it was filed. I think that will be a better proposition. The learned counsel for the petitioner submit that inadvertently the present revision petition was filed instead of an appeal. Accordingly, the what is the date of judgment?
Your lordship, order was passed
20th of
20th.
July 2018.
27.
2007 2018. Page 23.
Show your judgment. Show your judgment.
This order of the
No, the judgment you are relying on.
So far as this is concerned, it deals with the episcopal judgment, paragraph 15 and 19. Also.
No, this is not a judgment.
No, we are referring to page paragraph 15, page 20.
Paragraph
15, page 20. May I read that paragraph? There is yet another aspect of the matter. It has been held by the apex court in so and so.
where I mean paragraph page 14.
No, page 20, paragraph 15.
Page
20,
20,
paragraph 15. May I?
Paragraph period.
There is yet another aspect of the matter. It has been held by the Apex Court in Puduraja and other versus state reported in 2012 11 SCC 196 that the elementary principle of criminal jurisprudence in Commonwealth jurisdiction is that the accused is presumed to be innocent until he is found guilty in the trial, and over and above that, the acquittal rendered by the trial court would bolster the innocence of the accused. What that be the position? The Parliament has felt it necessary that stringent provisions in Section 378(4) of the CRPC should be engrafted so as to strictly fetter and regulate the appellate process to impugn involving the acquittal of the accused. It may also be noted that the cases covered under subsection 1 and 2 of Section 378, the Parliament has envisaged the appeals in which would be instituted only with the leave of the court. Whereas in case of acquittal in private complainants, the Parliament has emphatically mandated in 378(4) that special leave of the High Court has to be obtained before institution of criminal appeal to impugn the judgment of acquittal. So compared with the provisions of subsection 1 and 2 of Section 378, the other provisions facilitating appellate remedy, the Parliament has certainly envisaged a more strict and rigorous filtering process for criminal appeal could be instituted in acquittal matters, and such criminal appeals could be filed only after securing special leave of the High Court in terms of 378(4) the CRPC. These aspects could be viewed from the backdrop of principles of criminal jurisprudence that the criminal legal system should not be permitted to be shamefully perverted to serve the private purposes, and also taking into account the crucial principles that acquittal of an accused would bolster his innocence. It has to be seen, and these provisions as in Section 378(4) of the CRPC should be strictly construed for its effective enforcement, as otherwise it would lead to upsetting the whole scheme laid down by the Parliament for regulating the appeals against acquittal, which should be appreciated in the backdrop of these said crucial principles of criminal jurisprudence as mentioned here and above. Moreover, the beginning of the Section 4015, that's relevant, containing the words "where under this code an appeal lies," should be understood in the context of the requirement in that provision that the revision petition should be capable of being directly converted as an appeal, where the applicant is compelled at the threshold to seek a special leave for getting permission to file appeal. There is no question of directly converting the wrongly filed revision as an appeal, as the institution of appeal at that stage cannot be contemplated.
This is quotation from which judgment?
This is 2012 11 SCC 196.
This is the interpretation.
No, this is by
This is
High
the
Court,
judgment.
my lordship.
This is the interpretation. This is
Judgment at the High Court of Kerala, the Kerala High Court.
what Kerala High Court interpreted in that way. My interpretation
Very
is that.
No, I leave it to your lordship. I will place the judgment. The next one, next judgment of the High Court. That is there.
Part going to learned counsel for the petitioner. The present application is revision petition is filed assailing an order dated. Assailing an order dated 20/07/2008 passed by the learned additional chief judicial magistrate Sonipur, Tezpur, dismissing NI case number 124/2016 for default of the complainant, for default of the complainant, and accordingly the accused respondent number 2 was acquitted. It is the learned counsel for the petitioner. It is learned counsel for the petitioner submits that inadvertently a present revision has been filed, though an appeal against acquittal ought to have been filed. Full stop. Therefore, the learned counsel submits that in exercise of power under section 40(5) of the Code of Criminal Procedure, this court may be pleased to convert the present revision petition to an appeal. Par contra, Mr. Vonik submits that in case of an appeal against acquittal, first a leave is required to be granted to the petitioner, and without such leave being filed, no appeal can be without such leave application, the present revision petition cannot be converted. Consider the above submission. The consider the above submission. Full stop. This court while such submission was also advanced when the matter was taken up on 4/5/2023. However, after taking note of such submission, the court was pleased to call for the LCR. Call for the LCR. LCR has not yet been reached. Considering the matter in entirety, in the considered opinion of this court, the present revision petition has not yet been admitted on and only notice has been issued, the registry is to convert this revision petition into an appeal against acquittal, and the petitioner is permitted to furnish corrected cost title, and subject to filing a leave application along with such corrected petition. And please this matter
With continuation of
here.
Your lordship, whether condonation.
No condonation.
Michael. I am not in this case, below, but I am on behalf of Mr. Riyaz Tawada, who made a request to the adjournment. So he is suffering eye infection. He also obtained the consent of the petitioner.
This is transfer petition as agreed to by the learned counsel for the party. This matter after.
Right.
Any interim order?
May it please the Lordship, such a matter will be adjourned for the day, as my senior is not well.
Okay. In the prayer of the learned counsel for the important matter stands adjourned and be listed when
Any day.
after week. Any interim order?
No, yes, no, yes,
Interim order?
yes.
Interim order after that. Yes.
You asked to deposit rupees there, the 30,000 you lost, and according to the deposited amount, you must deposit time of the petition.
Okay,
of
the
idea.
learned counsel for the petitioner submitted in terms of
Audited 7/6
order dated right
7/6/23.
7/6/2023, an amount of rupees
30,000.
30,000 has already been deposited before
The trial court, your lordship,
the trial court. Full stop.
Maybe taken out for admission.
Okay. Let this matter
Yes.
be listed for admission once again. When
Your lordship, maybe
Lordship, next
fix to
week, lordship.
hearing your lordship. He
we'll
admitted.
hear at admission stage. Any problem? Okay.
Lordship, next week.
Next week may not be possible. Okay. 15.
Obliged.
May I please the Lordship? Lordship, by the consent of the other side,
Mm.
I pray before Lordship to kindly adjourn the matter for a day and miss it after 2 weeks.
As agreed to by the learned counsel for the party, please this matter.
Obliged.
Any interim order?
The transfer petition, Lordship. From Rongnia to Nagaon.
Rongnia to Nagaon. Yes.
Yes, ma'am.
Tell us.
But may kindly file, Lordship, page 9.
Page
Page 9, Lord.
Yes, tell us. What is the ground for transfer?
Actually, in this case, Lordship, the petitioner misrepresented himself as a Hindu boy. Lord. Actually, he is a Muslim boy.
Hmm.
And subsequently, when the petitioner came to know that there is a quarrel between them. They want a mobile phone, and subsequently, when he refused, they
These are the facts. What is the ground of
ground, Lord,
tra-
ground.
transfer? These are facts. Hindu, Muslim,
Lord.
marriage,
Lord.
children. These are facts.
Fact, Lord.
Why you want to transfer from Rongya to?
Wrong to Nogam, the live checking, Lord.
Huh?
Where California it threatened me if I came to Rongya, come to Rongya, Lord. So, in fact, what may kindly see page
What is
page
that?
11, page 11. Lord. I filed an adjournment petition there.
Then
Page 11. So the case is in evidence case, Lordship. I could not contest the suit, Lordship, because of this respondent.
proceeding is going on.
Yes, ma'am. So I, at present stage,
Your statement.
my lord.
What is statement that grounds.
Ground, Lordship, page 4, Lord. May I read the ground, Lord? For presently, the petitioner is residing at her paternal home at Pomuk at Nova and she is totally dependent on her aged parents. She does not have any source of income because she is pregnant.
You are the wife.
I'm the wife. Lord. Under the said circumstances, the petitioner is not in a position to appear before Rongya court to contest the trial in a state.
Will come back.
Madam.
You lost the affair at Rongya.
Rongya.
You married at Rongya.
Yes.
Now the allegation is threatening. How can she come to contest at your place?
Actually, my lord, there is no such type of threatening from my
The
side.
whole offense you are charge-sheeted.
Yes, my lord. I am
Already
facing the trial.
trial is going on.
Yes, I am trying. I am facing
Prima
the trial.
facie there is that allegations are stated to be true.
My lord.
Therefore, why should she face all this?
So matter may be tried by the Lanad Court below. I shall appear before the court and I am quite appearing before the court below to face the trial. In the meantime, no, my lord, at Rongya. In the meantime, the petition has been filed.
He is apprehending.
Actually, my lord,
Where is the judgment? What are the sections registered?
section 490 there alone.
490.
By my Lord Justice Gokoi in
Actually,
Supreme Court that in case of 498A, where the girl even takes shelter, that can be the place of trial and registering even affair. And yes, what is the judgment? Amit Goel was arguing, other side was Diganto that we passed the judgment. Crossing, we refuse to cross on that ground. Mr.
My
Goel
lord,
was the respondent, Mr. D, the senior advocate, was the. Okay, we'll come back.
my lord, I may be allowed to have another date on this particular ground if such type of ruling is available. I shall search for, my lord, because today
We'll wait for 5 minutes. We'll give you the judgment. Yes, you want some time.
I do not require time. Lord.
Okay, we'll
Ground
come
case
back
is-
at 2. We'll It is mentioned, it's hearing method. You are also there. This
Yes.
item number
20, my lord.
production. Yes. Why this method? I thought these are orders method, hearing method.
In this case, lordship, hearing is, I think, not required because matter has been infractual. Because from the date of arrest, they were inside the jail.
Okay.
In the meantime, conviction, they were convicted, and we prepared a appeal.
Okay, you want to say that in appeal we got acquitted.
No, lordship, no hearing could not complete because
In
of,
the meantime, the sentence was over.
yeah. And the fine period also over.
Over.
The one accused was inside the Central Jail Guwahati,
Okay.
and other was in Borpeta.
That's
That
why.
person is not released by the jail authority, lordship. That order is required, lordship.
Okay, now I understand.
Okay.
Yes. Pass the order later on. Let us.
Obliged.
Yes, item 20. Yes, Rupali.
Collected that criminal appeal.
Rupali Devi versus State of Uttar Pradesh. Huh?
Yes.
My lord. If it is so, the binding judgment of the apex court, it shall be binding upon us also. But
No, in fact, that case is not relating to transfer.
yes, my lord.
That was a issue where it was an objection that the incident of atrocity.
Yes.
That happened some in under state, say suppose state of UP.
Yes.
And the FIR was lodged in the state in Trivandrum. So it was that no cause of action, any part of it arose at Trivandrum. Therefore, it cannot be, it should be either passed or transferred to the UP court. But court says in this case that so far relating 498, where the victim is taking shelter, that place also said to be the cause of action arise. So in this case also, she is taking the principle. She is staying at Nagaon, and there are allegation is itself is a
My lord.
threat and all. Her seat has been admittedly filed.
Yes.
Trial is going on. I think this is a case to be transferred. If you want time to address, then we can adjourn it. It's not that if you are not ready, you go through the judgment,
Yes, my lord.
and if you want to interpret that in different way, you are at liberty. If you want the time, I have no problem.
My
granting.
lord, regarding their judgment, I am not going to say anything because I have not studied, read out.
So you go
But
through it. We'll
my humble
taking at it
submission-
next week.
My humble submission before this honorable court, that those grounds taken by the petitioner actually not justifiable and also reasonable. In
Okay.
view of the section 407
Seven.
CRPC. And on the other hand, it is PSC case arising out of FIR lodged at Ronga PS, and case is pending for evidence test. And as my learned friend has submitted before this honorable court, there's
This
evidence test.
No
Only
PW
one day is required.
no PW is examined.
No, yet to be.
How many witnesses are listed?
Listed only three.
Three, Lord.
50 men.
Lordship, my is the victim girl and a mother
And nothing more.
supposed to adduce evidence.
And we may be strictly directed.
I have filed an adjournment petition to a council because of this hate Lordship.
My lord,
There is nothing
nothing,
in the
yes,
application regarding faith.
Yes, yes.
If for
This is my
this
humble
reason,
submission.
I have
Yes, sir.
seeking adjournment.
I have also elaborated in
The
my
faith is
evidence.
only given in the present
Yes.
application only.
Yes.
If we allow it, this will remain as a precedent.
Yes.
Because there is no allegation as such that they have
Fitting was
pretended
there.
me that I will, therefore I seek an adjournment.
Yes,
That is not there.
Not there.
Normal
There
two-liner
was-
adjournment.
Yes.
So far as my instruction goes, Lordship. The
Your instruction.
FIR is not the laws.
respondent Lordship telephonically threatened this.
There
Where
is
is that material?
no materials.
Go to the court first, tell
Yes.
it that this is the situation, court may take action.
Yes, my lord.
Otherwise, in every case,
So this verdict shall come into light.
we are only considering a fact that there is an allegation of threat and therefore physical torture, therefore the FIR was lodged. But that threat may not be available as on date,
Yes, ma'am.
and you have not been able to disclose that. You have filed a adjournment petition on two grounds. Today is the date fixed for
Yes.
adjournment. Is not been able to appear, kindly adjourn.
Yes.
Adjournment
At
is
the,
done.
my lord, that petition was
Come a
filed.
little bit more prepared
My,
to get a relief, because we cannot give relief only on the emotions and that you are late. On the prayer of the learned counsel for the party, please dismiss sir. 3008.
my lord,
Think over it, because there is nothing on record to show that there is a threat to you or your family.
yes.
Nothing except in this petition.
And also no FIR was lodged. My lord. This plea has been taken by me.
Forget about FIR.
yes,
Even if
yes, ma'am.
FIR is not lodged, the
reason
adjournment
is-
ground
yes.
would have been that see I cannot
Yes,
come.
yes,
He is
yes.
threatened.
That was not
Court would
mentioned.
have taken a quiet.
No. ma'am. The plea-
Let us see how we deal with it.
30 August.
Yes.
Apply.
the plea-
Yes, sir.
Lordship, in my affidavit, Lordship, page number 35. Lordship.
Page
Page number 35, Lordship. I mark there, Lordship. This Sujata Rani Rava, Lordship. This is the mother of the
has the
informant.
serial number dated
Lordship dated 13/3/23.
page
Lordship.
35.
Yes, Lordship. 13/3/23.
Okay.
At the value date mentioned, Lordship. This
Sujata
second
Rani
Sujata
Rava
Rani Rava. And the
and
next is to Sujata Rani Rava. She is the mother of the informant, Lordship.
okay. Notice interim. You go and give a statement and
Yes,
give all
definitely.
this to your police officer.
Highly obliged.
Notice interim. Considering the materiality form, Robert to Taylor, including the additional affidavit and the record and huh?
Look, that will be had to be fixed for a case diary.
Yes, yes.
Let it be in the month of September.
Give any date.
My,
That's your prerogative.
my lord, September 21.
21. What is this item number?
Item number 6.
6.
This matter is for crossing of traffic. And what I find out from the ground that they want to show that the present FIR was maliciously lodged against them. And on that ground, they have sought for crossing of the traffic. They have enclosed the other documents, other FIRs which were lodged prior to that. And probably they want to invoke the column 7 of Bhojanlal case. That if a case is registered maliciously, then it can be crossed.
Malice in law, malice in fact, how we determine in a 480. So Santa.
I have to go-
Malicious.
Okay.
How we determine that this is malicious?
There is
On the basis of the FIR and other statements.
other thing. Because here the other ground, the
What
last
are the
ground,
other statements?
last ground they have taken is that 164.
Just for the informant.
Today is the first day.
The motion there.
Motion. Today is motion on.
Because there is a recent judgment of Madhya Pradesh High Court where FIR was relying on that Bhojanlal case. That it
No,
was
no.
malicious.
Bhajanlal's case, there is no doubt about it. Bhajanlal, subsequently many other judges,
Other one.
whether your case comes within that parameter.
Because that ground
FIR is
there,
at page 11.
page 11. And page 24 is the FIR lodged by their side,
FIR lost by.
petitioner side, page 24.
Page 11 is by the
But respondent number
victim.
2. Yes,
victim.
victim.
What is your name?
Um,
Sorry, fool.
sorry, for
And where is your
page
FIR?
24. Page
Huh?
24. Page
Page?
24. Type copy 24. Vernacular 26. That is the prior point of time.
This is lost by whom?
This is lost by Saiful Islam.
Sorry.
Sorry.
Who is this Abdul Hakim and Abdul Halim?
Abdul Hakim is the husband of the informant.
Aisa.
Yes.
This was lodged on 7/8
7.
and this was on 10/8.
10.
Probably my lord, FIR dated 7/8, that was not registered.
This is it is SARS is in frame already.
Yes. Someone was issued. Charge is not friend.
But charge sheet file,
Charge sheet file.
where is the charge sheet?
Charge sheet your lordship will find.
Why are you burdening us with this? I do not know. Can't it be argued during framing of charge?
Yes, my lord.
This
Otherwise,
is
my
not
lord,
permissible.
482 can be exercised even during pendency of
I
discharge.
understand, but even thereafter we can exercise our 480.
Got
At least we have certain materials before us. Now again we'll have to call for the case diary, statement. Why you can wait till that date, discharge?
Probably because someone was issued by the committal court and he is not under any protection. And if he go there, he will be put behind bar because this is sessions tribal case.
can
That may be the reason. Otherwise, I do not see
Otherwise,
anything.
can my
Because FIR, Mr. Borthakur.
Yes.
FIR is not.
otherwise, my lord, his main problem, your lordship, in my file, my lord, there is no designation. But my lord, the petitioner is approaching this honorable court for protecting to appear before the learned court of Chief Judicial Magistrate Lakhimpur for proceeding. So till now, he has not yet appeared
not yet.
in that case, my lord.
He was showing
So,
abscond.
Yes, maybe, but whether in a search sheet, my lord, he was shown as absconder or not, my lord.
Yes, on
I-
a contract.
Yes, and one another ground, he has taken that at the time of filing search sheet, no medical report, but in the search sheet, it is reflected that while filing search sheet along with the medical report.
So what is the way out
My lord, now
to
at this,
protect him and face the trial? Tell us.
yes, my lord,
What
better,
is
my
the
lord,
way out? Tell us. We'll pass that order.
my lord, now search not yet framed, so let him place all these down at the
So
time of
his
framing.
anxiety is that he will have to appear for the committal.
Uh,
Then committal court will
Then
say
till
this
then, he
is
will be protected, my lord. Till then,
376. Okay. All right.
till his appearance, my lord, him.
The petitioner case is that though he is a search-seated accused, he one single he is a search-seated accused and has been shown to be an absconder. The due procedure under section
207.
207 has not been followed by the investigating authority while declaring him as a absconder, in as much as he was always available in his residence. The residence of the alleged victim is also near his house, isn't it?
Right.
Therefore, till he is willing to appear and face the trial, face the proceeding before the trial court. Will not say trial.
Yes.
Face the proceeding before the trial court. However, as he has been declared as absconder, he may be arrested at any time. Considering the above material and arguments advanced by the learned counsel for the parties, so considering the matter in entirety, including the contents of the FIR as well as the alleged FIR lodged by the accused against the victim, but this court is of the view that till appearance before the learned trial court, the petitioner is required to be protected. Accordingly, it is provided that the petitioner shall appear before
For the
before the committal court
Jurisdiction
or
committal-
before the sessions court. Before the
before the chief judicial magistrate, Lakhimpur.
before the chief judicial magistrate, and on his appearance, he may be released on bail of rupees 50,000. Other conditions,
That's one, that section is lordship from 70 to 83 onwards.
80, I think what is the
72
procedure? 82.
Yes,
Yes,
ma'am.
70 to
Otherwise, my
82.
lord,
How
although
to declare a person to be absconder? 82 or 80?
82.
82.
My lord, here in this case, my lord, in all such state police, because he was not traceable, so there is no other words. So police has written he is absconding.
This is not that.
Yes,
Thing is that a few minutes ago, you have seen Mr. Mohanto
yes.
was arguing in a rare case, such a serious case, not even visited,
Okay.
not even visited the place of offense. He will get an acquittal in that case. I was thinking of granting him bail, but looking at the fate of that lady, here also,
yes.
though both are neighbors,
Mm.
one is BJP, other maybe Congress. That is the reason of fight. He says, I am in power, you can do nothing. These are the affairs in the
To the
past today to the
learned CGM Lakhimpur.
learned CGM.
Obliged.
Yes, your lordship.
Yes. You want admission?
No, my lord, motion will.
Motion.
Because, my lord, earlier it was followed, my lord, but with regard to the payment, my lord, your lordship was pleased to take instruction from my side.
What is your instruction?
Instruction, my lord, 40,000 they can accommodate me as on now.
Yes, then is submitted that the petitioner. What warrant you call it, Mr.
Distress warrant.
A distress warrant
Case
has,
number
has
53.
been issued by the learned
Additional civil judicial magistrate to India.
additional
Chief judicial magistrate.
chief judicial magistrate in
In
India for non-payment of maintenance to the respondent number 2. Full stop. Respondent number 2. The area is stated to be
1,78,000.
1,78,000. The learned counsel for the petitioner on instruction submits that he is willing to pay the amount in area amount in installment, and he will deposit 40,000 before the learned court, trial court below, trial magistrate below. By
Already disposed of
by
20 days time. we have time.
within a period of 20 days. Full stop. It is further contended that the current maintenance amount amounting to rupees 2,000, that the petitioner also submits that he will continue to pay the monthly maintenance amount of rupees 2,000. Full stop. In view of such submission, the
Distress warrant
warrant dated
dated 8/6/2023.
8/6/2023 is suspended for the next 20 days. Full stop. In the event the petitioner appears and pays the arrears of amount, the learned court below may consider the aforesaid consider the payment of remaining amount in installment. Full stop. It's installment. Full stop. That's all.
May not all, then the warrant may not be executed.
No, that we have said state
Till 20.
till next 20 days. We have said it.
Obliged.
Criminal petition. with aforesaid criminal petition stands.
Lordship, can be taken up after some time if my senior is on like.
What is the issue? Just tell us.
Lordship, is a case for, there's a complaint case, Your Lordship. This petition is for questioning of the complaint case.
Any stay
No, sir. The facts,
next week?
next. I think
Next week or thereafter? Yes, when? The prayer of the learned council for the respondent number
One.
matter sent as per can be
Our
listed.
seniors arrived, Lordship.
I have not. Equal. Well, it is a fight between the mother-in-law and son-in-law. And Honorable High Court was very pleased to send it for mediation. But my mother-in-law is so reconciled in nature that I will not even attend. Well, may I pray that another
Where is
attempt be
it?
made?
Where is your wife?
Why with
That
my mother-in-law?
That is the problem.
That is more dangerous, my position.
You bring your wife.
Wife will
and-
never come, my lord. She sent me into the jail asking.
Why? What is, what?
All 498. Nowadays it is a common feature. And thereafter, my lord, while I am in jail, my signed checkbook has taken away.
Now, what is the case? Passing of what?
My lord, the signed check, they take it stolen. I have given a law to the police station also. Then when I returned, I did not find. There is a lock in my room. They have occupied my place. Then, my lord, with those check issued by showing that I have issued my mother-in-law for rupees 8 lakhs, I have failed. That's why the case, criminal case, we have also filed. They have challenged all these things. We want peaceful solution. I cannot live with such a wife, nor she can live with me.
Have you filed any divorce petition?
I have filed. She said loudly in the Dhammaga teacher, I will never give. We shall say, we shall see who will give or not give. If my friend can help me, my lord, it can be ended. And the mediation in the Guwahati High Court, my lord, mediation center. Because that mediator did not play a proper role. What I have been informed.
The report is here, Your Lord.
Report is that
we
there was
appeared
no
for mediation.
cooperation.
Report there in.
Report
The
here.
report was called for. I think
Report of mediator's report we cannot disclose nor we can say anything. Do you want, are you
But that-
ready to have a second mediation here?
And what High Court.
once it is already done, Your Lordship, there. If Your Lordship directs, then
No direction. Is there any scope?
I
We
think
cannot direct
were-
husband and wife to live together.
there were two
That
two
is
rounds of-
beyond.
Yes, very true.
there were 2 rounds of mediation already, Your Lordship.
If you can solve out the problem,
Then
what is the
if
wrong?
one more attempt can be
Okay.
made.
The learned counsel for the politician.
No. Challenge to 125 proceeding.
Challenge of 120
No, not proceeding, my lord. Order.
order. How much was directed to be paid?
Only
5,000.
5,000.
Are you paying?
Lordship.
Pay it.
Saying as per last order dated, my lord, 6/2, this
Ah.
honorable court directed to pay 4,000. I have already paid an amount of 60,000 in total. Some areas is there, so my lord, I'm paying, my lord, I will pay 4,000. He is student,
What is that award?
5,000.
Lordship, I am having objection, Lordship.
To ask your client.
Yes, Lordship, on 15th of June 2023, Lordship, he solemnized second marriage. That way in a lavishing way, Lordship, with
Yeah,
the
it's-
attendance of more than 1,500 persons, Lordship. He is not, Lordship, may I kindly go through the judgment, Lordship. of the
We'll go
family
to
court.
the judgment. Certain things, judgment,
I
we
am not-
understand will go.
The husband is
What do you
bound
do?
to pay. I am admitted.
What do you do?
Nothing, my lord.
And why have you married if you do nothing?
Earlier, my lord, there was a love
And
affair.
because in
There was a
Indian
live
law,
affair,
Indian
they-
law is clear, even a monk
Yes.
is to,
Yes.
even a beggar is to maintain his
Yes,
life.
yes, sir.
Now,
I am already paying, my lord. 4,000 will be paid.
what is the award? 5,000.
Five.
If you can pay 4,000, you can pay 5,000.
Lord, that can be.
To file an application for enhancement. That there is a price of 50%.
I am not on merit now.
That's why. Lavish marriage.
Yes, Lordship. On 15th of June, Lordship. He is having no source of income, Lordship. Then why
He
he has
married
solemnized
once
second marriage?
again.
Yes, Lordship. On 15th of June, Lordship.
was
It's
not
1 month back.
That was their claim, my lord. I have already denied this in our.
Every Lordship may then, in that case, Lordship may allow me to file one affidavit, Lordship. I will bring it on record, Lordship, the photographs and the party videos also, Lordship.
Who passed this 4,000?
4,000, Lordship, on the last
5,000 passed by which court?
family court, Lordship.
Okay,
Family court.
you file announcement.
Yes, sir.
Bring those matters. The learned counsel for the respondent, praise for is granted. 2 weeks time to file an affidavit, additional affidavit. And both the petitioner and respondent shall also file affidavit declaring their assets and liabilities in terms of Rajneesh versus Neha
Neha.
reported in 2021.
2021?
Okay, let us see. Can you bring those photographs?
Yes, Lordship. I'm having the photograph, Lordship, even video also. The second minute. High level.
My lord, it seems somebody has mentioned, but both the petitioners and the respondents side are here. I do not know, my lord, who mentioned the matter.
File has also been stamped.
Now we'll see who mentioned.
Yes, my lord.
We can see it.
Yes, my lord. Who is
Might
VC
be
is
some junior, somebody says adjourn 32 P or
Yeah,
yes,
adjourn.
adjourn. What is the 20? Already,
Already
signed- already sign uploaded.
So my, after
Huh?
3 weeks.
Please after 3 weeks. No way out.
Deeply obliged, my lord.
Now you see the video in the
Yes,
evening.
my lord. Yeah.
Who has made them? Man? Yes, next.
Hey, please, Lord.
Yes.
Matter pertaining to question of order dated 26/2022 passed by learned additional district and section judge of special judge Ramya. And
Where is the order?
order is a page
Who is your senior?
NNB so
Where is he?
instructed me the case.
Why
Some
he is?
instruction is required from client, therefore
What instruction required? I think he has
Senior.
played away.
my senior is other
Your
person.
senior has already played away, giving responsibility to you. Where is what you want to be was to us?
Page, kindly come to page 26, mother.
Yes.
In this order, the learned court below allowed the prayer of investigating officer
Who?
and added section 27A of NDPS Act
Hmm.
subsequently. Kindly come to page. Kindly come to page 7, your lordship. Paragraph,
Kindly page.
page 7, paragraph 3.
Just a minute. Where is order dated 19/5/2022?
Kindly come to page 64, your lordship. In this order, the learned court below framing charge under section 25 and 27A of NDPS Act.
Yeah.
Subsequently, after 1 month, after 1 month of FIR, subsequently the investigating officer requested to the learned court below added section 27 and 27A and 25 of the NDPS Act, and the learned court allowed the prayer by order dated 22/4/2022. Page 7, paragraph 3.
We'll hear this case only when you're in your council. Any stay?
My lord, LCR was called for lordship, scan copy of the LCR.
Okay.
That has been received. And lordship, I would like to point out one thing, lordship, there are 8 asserted witnesses in the matter of search sheet. And out of the 8 asserted witnesses, 5 have already been examined. So whether the miss of this trial, my lord, trial even lordship.
That's why we want to hear NNB chosen. When? Are you having his diary? Nowadays he maintains diary. Ah, that diary. Tell us that. Seems this very much busy now.
My lord, it can be on 12th September.
Give us the date prior.
September. 29 September.
Huh?
29 September.
We want an earlier date.
I would have
12th of September.
12th of September.
But if Mr. Chaudhary is not here, we'll put heavy cost. Yes.
Opposite party to accept.
This was service complete.
Well, what happened? I purchased a plot of land. Now the original partner has appeared and filed a case against me that how you have purchased it. Then well, actually, what happened? I paid by paying 5 lakhs to 2 persons, those who have given me the power of Nitul and Ajit Charan. They said that we have got the power of attorney from the Patadar. Then our Patadar is saying that I have not given any power of attorney, the power of attorney is false. So I had no knowledge whether Patadar is having the actual.
Where is the complaint?
Complaint minute here. This is my page 15 minute, can you see? Annexure 1.
You are Moneshwar.
Yes. I have taken steps, my lord. The respondent has not yet appeared. They have appeared. Oh, name has been shown, my lord.
How do you know that you are not in the conspiracy?
Very
How
true,
do we
very true, my
determine?
lord. That's why, my lord, these
How
people.
do we determine?
Determine means I am a bona fide purchaser. I paid the money. How do I know that there is a conspiracy between these two persons?
Where is your proof of?
Now, my lord, the against whom I have filed this case, that they have not appeared. Let them come and say.
Where is your proof of payment?
Payment, my lord,
Where is your agreement? Where is your sale deed?
Sale deed is there.
Where
I
is
have
that?
not annexed. If it is requirement, I can prove. There is a serial list of the. Your lordship will find serial this sale deed. Serial list is there, page 30.
Which for the other?
Money receipt also there, my lord.
If you can
Deed of
make a
agreement, deed of agreement. is
fake
there.
power of attorney, you can make fake receipt also.
No, that is yet to be proved. That's true. Your lordship can.
That's why that's yet to be
Everything is
proved.
possible, my lord. That is true.
Everything is possible.
Yes, police investigation.
Can we decide on the face of the FIR that you are the
May I
genuine
pray
party?
that the status of the case is maybe false. What is
The
the
scan
Already-
copy was called for, lord.
Huh?
The scan copy was called for, whether it is
Can
received or not.
copies has been received, you go to it.
I know.
You go to it and we'll see. I do not think this is a case of passing.
Let him be on next week, lord.
Next, not today, not today. Give a date as per
My lord.
scan copy call for has already been received. Mr. Borua, learned additional public prosecutor, may go to it. This is put on the next date. list this matter
28.
on 28th. Yes, Mr. Kyal, what is this?
This is the case where our submission is that the learned CGL has
Mhm.
no jurisdiction to pass order for releasing the vehicle under custom act. This is the
Yes,
first point.
what is this?
My lord, another aspect, my lord.
No,
There is
no,
a first,
answer this aspect.
my lord, that aspect, my lord, that if we go on to that, this may not be required, my lord. Our vehicle is 6 months already in custody. And if notice is not served to us for constitution, we are, we are liable to be returned back
Under which act?
under the custom.
Custom.
Yeah.
Okay.
So, my lord, I only just pray that if my lord, my learned friend has any knowledge about it, whether knowledge has been, because we have not received any knowledge. If
Notice.
notice is not issued, otherwise also we will be entitled to get it back.
What is the status of the vehicle? Where is it?
No, it is in our custody.
It is in your custody.
In
Now,
offense.
how you respond to his argument that notice, if
No,
notice is not,
that is required.
it is required.
Under section
You have your instruction.
I'll take instruction.
It is submitted that submitted that Mr. Kyle, learned counsel for the petitioner, prays that he may be granted some time to obtain instruction whether the confiscation proceeding of the vehicle has already been issued, and if issued, any notice has been served upon the petitioner as the learned upon the respondent as learned counsel for the respondent submits that he has not received any notice. His client has not received any notice in terms of the Customs Act. Therefore, he is entitled for the custody of the vehicle as already 6 months has been over. In view of the aforesaid submission, let this matter be listed after this on
My lord, third date, my lord, in open, car is on open, and it is on finance, my lord.
8th of September.
But even then, if it is the lordship, the main question, whether the CGM has jurisdiction, because it is
That decided.
Yes.
They are not having.
no, because
If
lordship,
it is under customs, you have seized it under Customs Act.
no lordship, whether
Their CGM will have no jurisdiction.
yes, lordship, that's we want. lordship,
My lord,
because-
That if you want a pronouncement.
Yes, lord.
That CGM will not have a.
my lord, Delhi
Yes,
High
sir.
Court, one line.
Problem is in each and every FIR, most particularly Bitilnath, they are saying this is a Bitilnath of foreign origin. Moment they say it's foreign origin, where is their jurisdiction? It is your jurisdiction,
Yes, lord.
but you are not doing anything.
No, lordship, what happened? There were 6 cases
Hmm.
where this honorable court also held that the facts and circumstances the customer is not, because lordship nowadays problem is this, there is no levity in India to certify that these are the foreign made. And unless,
No, that may not be, but the place is important. Maybe bakes are important.
but lordship,
Suppose there is a foreign marking.
yes, then it is different. One case is going on where the petitioner approached this honorable court.
Uh,
This honorable court rejected their application. Now they approach the division bench court. But in one case, in 4 cases, we have been bound to release the goods because there was no regional ruler. They were seized in Kachar district. Because as per custom act, it not be within 10.
you both of you will have to
No, but-
where is Mr. Borthakur and you?
No, here,
You will have to find out a solution.
And lordship-
Otherwise,
in this case, lordship, the facts are different. Lord.
this is something different because this is admittedly seized by custom.
Yes, sir.
Moment is custom, that jurisdiction
Yes.
will not come. That is clear.
My
All
lord,
is clear.
Delhi High Court says, in case of customs also, my lord, one line, my lord, that it is apparent that despite the non-existence of a specific bar to the jurisdiction of court in the Customs Act to release of the seized goods during investigation.
No, tell us whether magistrate will have a power to try this offense. This is a custom.
My lord,
There is-
interim order. my lord.
There are some other authorities.
Yes.
There are
Commissioner.
first appeal, there
Yes,
are
that is
second appeal.
Commissioner.
All these are
Yeah.
there.
This-
How can a magistrate decide? Then there will be no appeal against that.
My lord, when the inventory list was, my lord, placed before the court, my lord.
No. Thing is, ultimately it will depend upon who is the authority.
Yes, sir. Section one
Because
one zero.
everything is to be done by a competent authority.
My lord, I only pray on that 6 month, my lord. But can it be preponed, my lord, because it's too long, my lord. Little bit.
Every cases cannot be
Yes,
preponed
yes.
because
No.
we are making some
My lord, vehicle is out of plan, that is not.
35.
And see, when then taken across the authority, Lord, there is no bar.
Yes, my lord, we
in a
can do that if that.
To approve, in the meantime, there is no bar
Yes,
for a petitioner
yes.
to approve the custom authority. And
Yes.
if such application is filed, the customs authority shall pass an order
Yes, my lord.
As per law.
in
In
accordance.
Okay.
Public.
Yes, Mr. Hazarika,
Maintenance marathon.
bad case or good case.
That is challenging one order of the principal judge, whereby petitioner has been directed to pay 5,000 per month and 1,000 for
What
final
you do?
water.
What is your profession?
Labor, man. As per in the last order, my lord,
Hmm.
petitioner was instructed to bring records, produce records regarding payment in terms of the order, earlier order passed by the honorable court in IA, dated 13/6, and accordingly he has already paid.
It seems there is no other case than maintenance, 5,000, 2,000, and Jimma of Tupari and Bay. Huh? From morning only
Yes,
maintenance of 5,000, 2,000, and Jimma of Tupari and this Bay. Now what to do today?
Lordship, otherwise, Lordship, area is also there. There are direction to pay regular maintenance and area 4,000 from area Lordship. They paid on 1/7, next day it was fixed on 1/8.
He's a labor.
Yes,
Or do you dispute that he is not a labor?
he's doing some business in Goa.
What
Not
business?
Fish and Lordship.
Yeah, same
That's-
thing. Selling fish in a cycle and doing
Good.
day labor. Same.
My lord, on a first installment, he paid 10,000, which as per direction of this court. After earlier, he paid 30,000 in the, he was not taking.
Now tell us what to do.
Lordship, let him regularly pay, but
But that is the-
that
I think that is
agreed
the-
amount, Lordship, 10,000 regularly pay in
Regularly.
case in case he fails, then consequences follow.
Huh?
That will be sufficient. Otherwise, huge area is there also. That will not get.
Yeah,
What to do?
junior friend, expected that he 6,000 is a little bit more, man. He's a labor person. And then area also is 4,000 also directed to pay. But
Both the council have a talk and come back to us. These are not cases for adjudication. These are consider. You better both council talk to your client and come to a settlement. Then come to us. And you continue to pay in the meantime. We'll fixing a short date. Yes.
Lordship.
Give a date. You have your role as a lawyer too.
Lordship, after
For
1
this we
September,
are wasting time and other criminal matters. People are
first
extra
week of
jail.
September,
Huh?
after 1st September, first week of
Give a
September.
date.
Next date is
Huh?
fixed on
13th of September. Please, on the prayer of the learned council for the parties, please this matter on 13th of September. In the meantime, the party may settle the matter amicably to their learned council.
he may be directed to pay.
He will pay.
Agreed amount, Lord.
The petitioner shall continue to pay the agreed amount. That is
10,000.
10,000. Okay, come back.
So there are two accused of it. They have completed their sentence. One has been released by Guwahati jail, another is in Barpeta.
So in which case
What?
we'll have to pass out?
138.
138.
130
In
criminal
145
appeal, 138.
In 145, he has been released.
Two cases, same person,
Same,
No,
2%.
two persons.
One
out of
was
one-
same judgment.
same judge. Art MS Nargis, learned council for the appellant and also Mr. Kyle Larned. You are a
Standing Council NCB.
standing council NCB. It is submitted by the learned council for the appellant that the appellant was convicted under section 70 C/29 of NDPS Act and was sentenced to undergo RI for 10 years and to pay fine of rupees 1 lakh with, in default, is not it?
Yes.
Yes.
It is submitted that the petitioner, the appellant has already served the sentence. However, the superintendent of
Borpeta Central Jail.
Borpeta Central Jail has not released the date. Mr. S.C. Kyle, Larned Standing Council NCB, has submitted that admits to the fact that the accused appellant has already undergone a sentence. If that be so, the superintendent of jail shall release the accused from custody in view of the fact that the sentence passed in connection with judgment dated 2022 arising out of 2022 has already been completed. If not in custody,
Yes.
in connection with
Any other
matter.
Yeah. Like-
Therefore, the criminal epic 138 2018
And other matter is in fact, also that is
the learned council for the 145 art MS Nargis and Secretary for the activity. The learned council for the appellant submits that this matter has become impactful in view of the fact that the accused has already the sentence period of sentence accused has already undergone the period of sentence and he has already been released
Yeah.
from jail. In that view of the matter, criminal epic 145 2010 then close being in
Much of.
IA all IS in view of order passed in 2020 all IS can
Much of.
Oh, that case, no reason. You are outside. Or no? Yes, wait. Pass this. So easy. Saying case of acquittal is very easy. Who would
I have prepared one, my lord, this index type.
this is
You have submitted.
this is Charge sheet of
FIR and my lord, repositions. Charge sheet copy color I didn't have, my lord. So I have just mentioned when that.
what who are the star witnesses for the
Mainly victim, PW4 victim,
PW?
4 victim. And my lord, medical evidence PW8 also. Main evidence is my lord, PW4, that is victim. And PW3 is his brother, my lord, is informant.
Because he is not transferred. That is the ground.
That is the problem.
Because he said this man was here.
Yes.
Dulal Hazarika. Dulal was not even here. Some witnesses say that the other landowner, he was in front of somebody's shop or something like
He
that.
was in the
Is not it?
Yes,
Shop.
DW1.
At that point of time, he was in the shop of one, some Provin
All
Barua, DW3, and someone.
And DW3's evidence remain
that-
unshaken.
Yes. At that,
So which story to believe? There is a
there
doubt.
is a difficulty. And at that point of time, one Dilip Barua came there
and my lord intimated the present accused that something happened in his house, and thereafter my lord immediately he rose to that. That is the statement of the DW witnesses. And in the FIR, my lord, while the brother of the informant, the brother of the victim, he lost the, at that point of time, incident occurred on 2/1/2004, January, my lord. And on that day, my lord, thereafter on 3/1/2004 FIR law. On that day, the brother, that is the informant in the FIR, he has stated that at that point of time, he was in a position to speak. And before the doctor and the informant, he stated the name of the present accused, that is my lord, Kamal Barua. And thereafter, while my lord, at the time of initial deposition, he has not stated that before the doctor, my lord, he named the present Kamal Barua. And he also stated that immediately there he my lord, made the victim only after 2-3 days thereafter. And initially,
Victim died when? Or not died?
not died, my lord, 307.
He was in hospital.
Only thing disturbing is how it happened.
Yes, sir.
That itself is a doubt. If that doubt is there, it's in case of acquittal. How the incident?
Incident inside that house, in the
That is established.
establishment, there is no doubt.
That he had burn injury. That incident took place in the inside the bathroom. He was found in a burnt condition inside the bathroom with his hands tied and legs tied is established.
So, my lord,
now the question comes, who are those persons? Prosecution has failed to establish the presence of these 3 persons in the place of offense. Had that been established, that would have been different. Yes, one point is established that that wife was there.
wife was there. His
Wife was there.
his son was also there.
His son was also there. So if his son and daughters were there,
Son and wife. Son and wife.
son and mother is there, who other than these 2 will commit this offense?
Otherwise, from the type
Let us
of
think in a different
Yes,
way,
yes.
in a convicting mode. Nobody was there. Coming to the other point that he has not seen anybody who used the force and who beat him up, can be a believable thing because he was inside the bus. But he was very clear what happened in the room. Up to bathroom, who were there, he specifically stated. Inside bathroom, he says it was dark, so I could not see each and everyone's role. That will not negate his statement before statement that he was beaten up and demanded money, LIC and all. But what should be the motive of this? Motive sometimes important.
motive never come out.
Why should they do this?
And otherwise, from the incident, how the incident happened, and the way at that point of time the victim was found inside the bathroom.
There is no
This
other
is
who came to the place.
because this is not possible for a single person to take him to a bathroom. Thereafter, tied with rope in his legs and hands, my lord. So, my lord, definitely from the facts and circumstances, my lord, all persons are 2-3 persons are involved.
Points this person.
Yes,
That we understand.
Yes.
But only problem is that it was a person was not even sent for trial. The other person,
Dulal Hazarika.
Dulal Hazar was not sent for trial.
Wife not
If Dulal Hazarika's story was wrong, how can you put trust on this victim?
Otherwise, my lord, lapse of investigation is also there because, my lord, at that point of time, although my lord, he has stated that about Dulal Hazarika, and regarding while police investigated, IO investigated the matter regarding whether any Dulal Hazarika was present there. Dulal Hazarika also, my lord, appeared as DW4, but only stated that one superintending engineer who at that point of time Dulal Hazarika is working under
Who is
him.
the superintendent?
His
Nothing
name is also
there.
not there.
Nothing is there.
Name is also not there, and he was also not even interrogated. That is the problem.
Generally, injured witness,
Yes, my lord. He is the best
best witness. But here the case is that because of this Dulal, he said specifically Dulal's name and the object and motive why this has been done. Dulal is relative of his wife. But ultimately, police says Dulal was not at all involved. He was not even present on that day. And why then how you trust this witness? If you cannot trust this witness, then it's a doubt, moment doubt, criminal case. With my limited knowledge, I only know that if doubt is created, nothing more is required. CAV, will think over it.
One judgment, my lord, suspicion, however strong, my lord.
Suspicion, however, that's true. And give judgment on that trustworthiness of injured witness when can be done.
Yes.
Otherwise, we are tilting towards acquittal. Had this Dulal been charged, there would not
My lord,
have any.
anyhow, in this case, my lord, Dulal Hazarika is somewhere involved. So, my lord, my lord, version of the my lord victim last time, maybe
Dulal
after
is
thought, my lord,
Dulal is being brought by the husband of this lady. Dulal, his wife is Dulal's not direct, not cousin and all.
anyway, my lord, initially probably victim know that Dulal is
This
not
man
involved.
was brought to the house and to the garage by the lady. And this is the
Yes.
reason why this person was beaten. And to save himself, that I was not involved in any kind of things, he brought the false story of demanding 1 lakh rupees and LIC policy.
LIC policy.
Whereas he is staying in a garage. He has
Yes.
no place to stay. This is the story. Is that it, Mr.
Yes.
Chaudhary?
But-
Nothing more than that.
But he is using the bathroom of the my lord.
That's why
Common bathroom.
a person who stays in the garage, no place to stay. The lady brought him. He uses the same bathroom which the lady uses.
Earlier, my lord, that lady was working in a
In the
place,
same
Janambhumi.
place. Both,
Place,
he
and
was also
thereafter,
doing
my lord,
that.
yes, yes.
That is the difficult thing. That's why he was mercilessly beaten up by this
Kamal Baba.
Kamal Borua and his son.
Exactly.
And the other person, he thought that let me involve him. also.
Yes, exactly. Well, already probably he has some enmity with him.
Already,
And
but all these ifs and buts, moment ifs and buts, acquittal.
Yeah.
But we'll have to pass it properly, not dictating in that way. CAV. But it will take some time.
yes.
This month, not possible.
Also, Lordship will also consider the defense witnesses
No, definitely.
because he was nearby place, my lord. Somebody informed my lord. Then
Even
can-
some PW says that he was in the stop. Some
yes, but that Dilip Barua, who as per the DW witnesses, who has informed the present accused that something happened in his house, but that Dilip Barua, he is not stood as my DW witness.
but some vital witnesses were also not examined. Anyway, we'll see.
And suppose while the informant in his affair stated that before the doctor, my lord, he deposed the present injured, that my lord, that entire my lord, accused of this person named Kamal Borua at that while lodging the affair. But later on, that doctor was also not my lord examined. If my lord he has stated anything, my lord, before the doctor.
Difficult. Yes.
Problem.
Like you want to say something.
167, my lord. What is the MICA? It's a PC Act, conviction of 6 months, and my lord, fine of 5,000.
When? Date of judgment?
Date of judgment is of 2009, my lord.
What was his age?
My lord,
What was the age of this man
that I have to
at
find
that
out, my
point
lord.
of time?
At time of appeal, my lord, his age was that, my lord, this is not specifically clear in this paper book which is provided to me. But that apart, my lord, if my lord goes to the ground of conviction, specifically, prosecution.
Is CBI?
No, my lord, special court under PC Act.
Okay.
Lordship goes to page 139 straight away.
139
Oh, yes, 130.
of the paper book.
Paper book.
What is the paper book? Paper record. Record or paper book?
I have, this is, my lord, this is paper book, I think.
See, you are
This
having
is-
a paper book, the judge is not having.
The court, my lord, Mr. Botakur can perhaps help out. Paper book 9. I have also, my lord.
You are privileged
For today, my
because
lord.
you are MI cast.
For today.
Give it to her.
Ah,
Have 2 copies. Some other day.
Can you fix them, my lord? But
Give it.
Amicus matters, my lord.
Give it.
My lord.
Forward, Senator Michael, to Mr. Botakur. So a paper book is available with the learned MI cast paper. No copies are available either for a court or for the learned public. Accordingly, the registry shall make 2 extra copies of the paper book from the copy of the learned MI within a period of
29, 30 or 29, hearing date. 35.
within a period of 10 days. Hereafter, please this matter of 29. You give a copy.
She can take I'll take it back after 2-3 days. Just let her retain my lord, I'll take it.
Yes.
Obligation.
Picking up tomorrow, my lord. My senior is on legs in court number 12, my lord. After some time.
Not tomorrow. Tomorrow list I think already over.
Next Tuesday, Wednesday.
Next Tuesday, but here old. Yes, Mandan, what is this?
Matter, your lordship.
Came up at 3, is it a case to be taken up at 3:15?
That will, I'll leave it to your lordship. But this matter has some complications, which in fact, I have got 2 types of views here.
Therefore, let us not start it at 3:15.
I leave it to you. Whenever your lordship desires. My learned friend, he is more interested than me.
No, I
Mandan is enjoying a stay.
Yes, my lord.
our money is stuck, that is the only thing.
Negotiable instrument.
Under NIA, actually they.
The only issue that has to be seen is, just, I'm not making a submission, just
there-
making a point that the person concerned was convicted, appeal, appeal was allowed, sorry, it was rejected. The conviction stayed, conviction was completed. Then the default was there. There is a default if you pay the amount, and if not, you have a default. The default period was also undergone. After undergoing the default period, when the person came up, then an application was filed under section 421 of the CRPC, saying that he should pay back the money. The person concerned did not appear initially, so she was arrested and put behind the bar. After behind the bar, she was given notice that you pay the amount. Then after one, I think she consulted the lawyer said already the default is also completed. Then when the court went into it, found that yes, the default bill has also been completed, the default period. So now she was allowed to go on bail. Thereafter, we came before this honorable court for quashing the subsequent proceeding with regard to court.
According to you, my judgment, conviction, sentence, everything is over.
Yes.
Now why should I pay?
Yes. That is
If
one.
I would have to
That
pay.
is
I would not have gone
Yes,
to
the default.
that place.
That is one part. Second part is that even if, for example, I am brought before your lord, before the court for the second part of payment. Now I don't pay. I'll be again put into jail. Cannot,
No, not that
because
is-
second time you cannot be put in jail
Not jail,
for the same offense.
The recovery process is there as per section 421 CRPC. It will go as recovered as areas of land as per 422. That process will
That
follow.
process will be,
That is
I've done
Baki
so.
Jai. Assam
Madam,
Public Bengal.
like Baki Jai.
Assam-
Yeah.
Assam-
that is
That
Baki.
So
But
that process will follow.
here is again, there is a proviso given in the act which says that you can. There are two
No,
judgments. One my learned
No,
friend
one
has,
have
I
already
think,
placed
already
earlier
placed,
also.
that is a
It is
Supreme
in the
Court
record.
judgment.
This will be the interesting point.
Yes, and one judgment that I have
So
provided.
just
In
because
that
she has
judgment,
undergone
This
default,
matter is hearing matter.
Hearing.
admitted. Let us fix it at order stage. Because after 350, Mr. Mannan, you know,
I am with your lordship.
isn't it?
Yes,
only thing is.
I am
Brain should work to do dispense justice.
exactly.
Mhm.
Even
Yes.
we also need a mood to argue a matter like
Yes. I don't.
Yes.
Publish this matter in the order column on 30th.
Must-
Mr. Hazarika, RNB Chaudhuri. Oh yes, we are having something. Yes, come forward. Yes.
Item number 34.
Yes, what happened?
The petitioner and to respond.
What order did you pass?
Uh,
So what do you want?
Our name may be
Okay. Oh, your senior's name.
Yes.
Where is Mannan has gone? We need an advice. A case was adjourned for 2 weeks in absence of the lawyer.
which case?
One case.
Yes.
Now, a request is made that the senior, by mistake of junior, it was nobody was affected. Now says that it should be said that not non-appeared, but represent. We can record his name, but can we record that the senior counsel so is present?
No,
No.
that cannot be.
Yes, what is his name?
P. Talukdar.
P. Talukdar, huh? P. Talukdar. We cannot register record.
Yeah.
You might have some disadvantage, but
But
we-
still you-
we cannot do that. Yes. Thank you.